My lord, with the consent of the other side, I'm mentioning item number 74 and 75. That consent. Oh.
Today is a day when I'll start with the mention. You see what is happening? We are getting a lot of mention memos for taking up matters in the admission column in this last week. So I do not plan to take up 22, 23, 24 matters for hearing at the admission stage in the last week. I'll take up old matters. If you are ready to take up for admission 11, 12, 13, 14, 15 matters, I am taking up. But relatively new matters for disposal at admission stage at the time of just before the vacation, I am not taking up. So although the matters will be listed as mention was allowed, but those matters will not be taken up for hearing. Old matters will take up, new matters in admission stage will not be taken up. So this is the court mentioned. Now, yes.
My lord, with the consent of other side, I'm mentioning item number 74 and 75, the content matter, my lord.
Yes.
The order has been complied with. DPC held, promotion given. He is joining. They were communicated the order even, my lord. But we'll bring it on record, my lord, by an affidavit.
Okay. 74, 75.
My lord.
Okay. Both sides are represented. Mr. Adhar and counsel for the respondent has submitted that as per his instructions, the order of the court has been complied with, and after holding a fresh DPC, the petitioner has been promoted. To stop. He, however, is leave for some time to bring the document on record. Matter stands adjourned today. List after ensuing vacation. Summer vacation. Yes.
May you please also I beg to mention for listing of 3 WPCs.
Please give it. It will be all subject to what I have said. All mentioned to the court master.
And may I mention this? 830622 last posted for listing 19524. The matter relates to claim of
Please give it to the
OPS.
court master.
Okay.
Those matters, if it's not an old matter, will not take it up for hearing at admission stage.
May I please your lordship? Lordship, I beg to mention item number 16, lordship.
16.
16, lordship. Kindly pass over the matter for the day, lordship.
16. Okay. On the prayer midway and counsel for the petitioner, pass over for the day.
Wait, please, your lordship. Lord, I beg to mention item number 8 of your lordship daily list, my lord. Now, I have instructions not to press this matter, my lord.
Okay. Mr. D. Goswami, learned counsel for the petitioner, upon instructions, submits that he has instructions not to press this matter. Accordingly, this writ petition stands closed as not pressed.
Repeat, lord.
May I please your lordship? Item number 73, lordship, contempt matter, lordship.
Item
73, order has been complied. I have informed the other side at 2 p.m. lordship.
Okay.
73
Okay.
at 2 p.m. lordship.
My lord, I beg to mention item number 38, my lord. We have taken consent of the other side, my lord. Matter may be adjourned for the day. I am appearing for Seva, my lord.
Lordship,
38.
38.
There was some compliance was required.
Yes,
What was that?
my lord.
You were to do something.
Yes, my lord. Now, my lord, today fixed for, I think hearing
admission.
admission hearing.
Lordship,
Okay.
since next week is motion week, my lord. Tuesday, my lord.
No, not on Tuesday. Wednesday.
Oblige, my lord.
Okay.
Can it
Item
be on Thursday,
38.
Lordship?
Item 38.
Wednesday, we-
Also is represented on the prayer made by Learned Standing Council for Seva. List on. Yes.
Thursday, Lordship.
May I please, with a concern of the other side, I'd like to mention item number 20.
20.
My senior could not come today.
2020.
Okay. It goes after vacation.
After that, you know.
Okay. Both sides are represented on the
Interim
prayer.
may kindly be continued.
Huh?
Interim may kindly be continued.
Okay. On the prayer made by counsel for the petitioner, matter stands adjourned. Interim order past release stands extended to the next date of listing. List after the ensuing summer vacation.
Keep that, please.
I'm praying for listing also after a vacation also, if it is.
Whatever, leave it there. We will take care of it.
May I please your lordship? Lordship, I beg to mention item number 45, your lordship. With the consent of the other side, your lordship, I'm responding number 2 and 3, your lordship. Lordship, your affidavit is ready for sent for vetting, your lordship. So lordship, kindly matter may adjourn for today and list after vacation, your lordship.
Okay. Both sides are represented. On the prayer made by legal counsel for respond numbers 2 and 3. List after ensuing summer vacation so as to enable her to file affidavit in opposition in the matter.
Interim may be continued.
Interim order past release stands extended till the next date of listing.
Interim may be continued.
Bless
With
you.
the consent of others, sir, I beg to mention item of 46. Okay. In this case, we are appealing for response of 1 to 3. We need 4 weeks time for filing affidavit in court.
Okay. Both sides are represented. 4 weeks time is granted to the counsel for respondent numbers 2,
1 to
3,
1 to 3, all
1 to
legal.
3. For filing affidavit in opposition. And the interim order is there?
No,
Okay, list after ensuing summer vacation.
okay.
May it please your lordship, with the consent of the other side, I beg to mention item number 48 of today's daily list, lordship. In this matter, we will be filing an additional affidavit, lordship. Bringing some medical documents.
Okay, both sides are represented. On the prayer made by legal counsel for the petitioner, the matter stands adjourned today. List after ensuing summer vacation.
Lordship, there is an interim that may continue.
Okay. Interim order passed. This is that transfer matter.
Yes, lordship. Lordship, the petitioner will be, mother of the petitioner will be appearing before the disability board today, lordship. It will be bring-
Has a date been fixed?
According to Mr.
Today's-
Muzumdar, today she is going to appear before the board. She had appeared before GMC yesterday and they recommended to appear her today before the board. So I fixed it in the month of July last week, lordship.
List after ensuing summer vacation. Interim order passed release and extended in the next date of listing. Make a mention if it is not listed.
Much of.
May please your lordship, I beg to mention item number 22, lordship. Matter this matter wrongly listed this matter, lordship.
Oh, it nahi.
Matter is relating to foreigner tribunal.
No, 22 is deleted, I think.
Delete it.
It's deleted.
Item 63 for delivery of orders.
This repetition is dismissed. It is interpreted that the notification dated 15/11/2014 cannot be read as if all persons suffering from any accident, except hit and run cases where the offending vehicle remains unidentified in the final form after police investigation, would become entitled to ex gratia, where other statutory remedy is available. Mr. Hendik and Mr. Bapujari, for you also. This 15/11 notification,
Yes, sir.
I've interpreted that it will not cover accidents except hit and run cases.
Yes.
But then what I did was that the Standing Counsel for the Revenue and Disaster Management Department shall communicate a copy of this order to the head of the Department, Revenue and Disaster Management Department, to examine if it would be appropriate for the government to issue appropriate clarification. As giving support to the family of the deceased in a road traffic accident comes within the policy decision of the government, it is made clear that while issuing clarification, it will be open to the said authority to take a view which may be contrary to this judgment. It is clarified that in the event the government does not issue any clarification within the outer limit of 6 weeks, or the clarification that may be issued in favor of granting ex gratia for those who suffer motor vehicle accident and make a claim before the motor accident tribunal. In that event, the petitioner will have a right to make fresh representation seeking ex gratia compensation. So unless you clarify now.
Absolutely, my lord.
Yes.
In fact, my lord, last November 2023, the Revenue Department had issued a notification whereby, my lord, in this category of cases, except what lordship has held, except hit and run cases, my lord, matters, all other matters have been excluded.
Sure,
There
the
is a-
notification?
Yes, sir.
You have a copy of that?
Yes, my.
What is the? You made it to the court master, will make necessary correction in the order if required.
I will just
You-
now furnish it, my lord.
You
I
sent it by.
I have a soft copy, my lord.
Yes. Next.
To be spoken to item 64, 65, and 66.
Mr. Saivana, some of this slipped my mind. I did not deliver the order. I just listed for hearing today so that I can cover up
My
that
lord.
period.
My lord.
The orders will be delivered today only.
Much.
It's only because of that gap. Otherwise, the order becomes.
Any-
Yes. Just wait for a moment. The order, I'm getting it. out. You may leave because Junior may be here.
Yes.
We'll deliver the orders.
Yes.
Okay, it will take some time. After, at the second half, we'll deliver.
For withdrawal, item 67.
May I please, your lordship, I may be allowed to withdraw this petition with liberty to file a fresh, my lord.
Why liberty?
My lord, we need to add some more particulars in this petition, my lord.
No, you see, once you are asking for leave, you'll have to explain.
Yes, my lord,
Because
some
they
more,
can't give you a blanket leave. You must have clarity, what is the defect? Because I must record it's a formal defect.
Yes, my lord. Some more annexes are needed to be added in this petition, my lord, because earlier those annexes were not obtained. The petitioners, they could not provide the annexes during the filing time of petition, my lord, for that reason.
Your name?
A Basumatari, my lord.
On instructions, say Basumatari, learned counsel for the petitioner, seeks to withdraw this petition as certain annexes were left out. Mr. S. Datta, learned standing counsel for the PNRD department. Mr. V. Chaudhary, standing counsel for the respondent number 5 are present. Matter is dismissed for on withdrawal with liberty as prayed for.
Obliged, my lord.
Daily list item 1 for motion.
May please, Your Lordship. What is the date of the order?
Date of is 10/4/24.
10/4/24. Mr. S.R. Gogoi. Content. Take steps within 2 days. The eternal date the court master will give after some time, after 5 weeks. Pendency shall not be barred.
Item 2.
Yeah, please, Lordship, the matter was last listed on 12/6, my lord. It is a my lord transfer matter, my lord. My lord, the petitioner, my lord, in my lord, agent process posting, my lord, from the headquarter, my lord, Tezpur, my lord. And he was.
Just a moment.
Lordship.
Where is your medical document?
Yes, Lordship, medical documents, my lord, I have a next, my lord, page 33, my lord. Page 32 is a my lord treatment certificate before, my lord, the mental hospital, my lord, LGB Regional Health Institute of Mental Health. And my lord, the medicine, my lord, page 33 onwards, my lord. Before the psychiatric department, you know. And representation, my lord, he is not, my lord, not want to, my lord, continue his present place.
No,
of
no,
business.
none of these prescriptions indicate that the wife is suffering from mental illness.
Lordship.
Lordship directed to
The
place.
medicines given, amitriptyline 25 is for migraine.
My lord, in this regard, my lord, I have, my lord, some, my lord, page, kindly see, my lord, page, my lord,
No, it's okay. You see, somebody may be taking an antidepressant. But merely because antidepressant is being taken doesn't make anyone a mentally ill person.
my lord, the page 33, 35, and 37, my lord, kindly see for a moment, my lord.
No, prescriptions are not proof of medical diagnosis of mental illness.
On, my lord, 15/6, my lord. My lord, it is.
You see, it may so happen that I start reading. I wake up at 6 o'clock. From 7 o'clock, I start my work in the table. Till right 12 o'clock, I am in my table, either here or there in my home. So I may develop an insomnia. And it's every likelihood that a doctor may prescribe me some antidepressant. That doesn't make me a mentally ill person.
My lord, she is now, my lord, the treatment is going on, my lord.
Pardon me?
Treatment is going on, my lord, before the, my lord.
No, treatment is okay,
mental
but please
hospital,
show us that it's mentally ill. We have our limitations under the Mental Disability Act.
My lord, after, my lord, the on 15/6, my lord, petitioner also, my lord, again, my lord, exposed before the, my lord, the mental hospital, my lord. One documents, my lord, I have with lordship permission.
Under the Mental Disabilities Act, we just can't, we have limitations on our power to declare somebody mentally ill. Even referring to a person as mentally ill is a crime. That's it. It's a Mental Health Act board, huh?
One certificate also, my lord. Issued by the, my lord, the Jasper Medical College Hospital, my lord. Now, where, my lord, it is reflected, my lord, F32, as per, my lord, ICD 10.
This medical term F32, I don't know what is,
I had, my lord, some from Google, my lord, I have searched, my lord.
is good. It does it. You know, Mr. Dengia, after that Pune episode, this medical certificates is always subject to scrutiny. You take the entire treatment at LGBI hospital, correct? But when it comes to this diagnosis of F32, you go to a private doctor.
Yes.
Why, if is the LGBI incompetent to diagnose F32?
My lord, what happened, my lord, the treatment is going
No,
on.
I understand. You see, I go for a treatment, I go to AIMS. And for a certificate, I go to a doctor at, say, Patna.
You, my lord, 13 times, my lord, already petitioner, my lord.
I understand that is India's one of the best institutes, LGBI Tezpur, is incompetent to diagnose F32. They don't say anywhere that you are diagnosed with F32. A private doctor gives you a certificate. How does he do the diagnosis? It's a major condition. What the LGBI could not do, this doctor can do it. No doubt. We can at best ask you that you can avail the facility at your, whatever choice you have in the, you're in which force?
SSB.
SSB, my lord,
Huh?
Sashastra Seema Bal, my lord. SSB, my lord.
SSB.
Lordship.
If you want your medical condition to be assessed by the doctors at SSB, wherever they want to get you checked, you can do it.
Right.
But no case of stay or transfer.
My lord, he is, my lord, not want to continue, my lord, at present place of posting, my lord. That is why, my lord, he filed a representation, my lord, 5 sources, my lord. As per the, my lord, transfer, my lord, the circular, my lord. Annual transfer circular, my lord. Kindly see, my lord, page 59, my lord. Within the zone, my lord, so that, my lord, he may, my lord, some, my lord, treatment which is quite, my lord. And my lord, present place of posting, my lord, it is a, my lord, the Yoksum, my lord, shipping,
Just a moment.
lordship, my lord.
You have a copy of this Mental Health Act with you? Mental Health
Yeah,
Act.
my lord,
You
my
take
dis-
this.
disability.
You see 105. $105. At best, when the issue of mental health comes, I can refer you to a board. Court has no other power. Please read loudly. I have forgotten. I will also remember.
My lord, 102, sir.
105.
Lordship. Questions of mental illness in judicial process. If during any judicial process before any competent court, proof of mental illness is produced and is challenged by the other party, the court shall refer the same for further scrutiny to the concerned board, and board shall, after examination of the person alleged to have a mental illness, either by itself or through a committee of experts, submit its opinion to the court. Yes, Lordship.
I can at best send
I
it to
also
the
agree.
board. They will abide by that.
Yes, Lordship. I also agree, my lord.
But this has to be done.
Yes.
Once he's saying F32. But you bring this on record by way of an affidavit.
Lordship, Lordship.
And there is also a bar. There is a provision somewhere which says that a non-professional, they have restrictions to practice in psychiatry. The board will be constituted by your authorities, or it will be by the
Expert, maybe one from the,
no. What is the procedure of board? It will be constituted by the medical college, or it will be constituted by your authorities.
in generally lordship, from both persons, 2 experts from, one from
No, I am not on the constitution.
lordship.
Who constitutes the board? It's
Board
the
is constituted by,
medical college, concerned medical college constitutes a board. Or it will be your authorities who will constitute a board.
generally authorities constitute the board.
You
Yeah,
constitute.
yes.
Heard Mr. Allen being here on a counsel for the petitioner. It is contended by the petitioner that his wife is suffering from certain medical conditions which require him to take care of his wife, and moreover, he has a minor son and a minor daughter who are also required to be taken care. Full stop. The learned counsel for the petitioner has produced a medical certificate from a private doctor indicating that the wife of the petitioner is suffering from a condition medically known as F32. Full stop. Next paragraph. As it appears that the condition of F32 may be construed as a specified illness, comma, in view of the provision of section 105 of the Mental Health Care Act. Where is that book?
2017.
The court deems it appropriate. The Act Mental Health Care Act 2017. The court is inclined to direct the competent authorities in the Sashastra Seema Bal have the wife of the petitioner examined by a mental board, by a board. Full stop. It is also provided that in the event the SSB does not have the power to constitute a board, comma, the SSB shall make a request to the Tezpur has a hospital,
Tezpur Medical College is there.
and Tezpur Medical College and hospital, comma, Tezpur to constitute a to board for examination of the condition of the wife of the petitioner. What is the name?
Wife's name, Lordship?
Gitali.
Gitali Devi.
Mrs. Gitali Das.
Gitali Das, sorry.
Full stop. In the meanwhile, let a notice of motion returnable on so and so due date after 4 weeks be issued. Requisite extra copies of the writ petition be served on Ms. B. Sharma, Lanet CGC, who accepts notice on behalf of all the respondents. Full stop. Next, till the decision of the medical board on the mental condition, on the health condition of the wife of the petitioner, comma, where is the impugn order?
Impugn order on page 44, my lord. Page for transfer order, my lord. Petitioner's name reflected, my lord, page 45, my lord. Serial number 257.
The order of transfer number, page 44, number so and so, dated 12/8/2024.
12-4 minute.
Uh,
Yeah, type
come on,
minutes.
insofar as the petitioner whose name appears at serial number
257 minute.
257, comma, 11090910910, Jogen Bania, comma, F capital small tr, headquarter capital H, QR small, Tejpur. Sorry, from FTR headquarter Tejpur, TO2, 72 battalion, shall remain suspended without affecting any other transfer made in the said order. There. If you notice a motion, they say that we learn a CBC opposes the prayer for stay.
Lordship, one difficulty that those documents are not a part of record, neither it is
Uh-huh.
served upon me, Lordship. So
No, we also say that the additional documents produced by the learned counsel for the petitioner shall be brought on record by way of an affidavit and a copy thereof. We also served in course of the day today to the learned CGC. Obliged.
9th of August. Item 3 for motion.
Yes.
In this matter, I have completed my instructions. There are two aspects of this matter. The public interest, there is a definite public interest, but apart from that, your lordship, the notification on which the petitioners are relying, your lordship, to say that the chief minister's approval is required, that is only for gazetted officers, your lordship. That is only for gazetted officers. That has been clarified by the personnel department. That notification is there, your lordship. It is the last page, your lordship, of the instructions. And the specific written instructions from the commissioner are the posts of the petitioner, they are non-gazetted posts. Your lordship. So that notification will not cover them.
But still you have to tell us what is the reason of
Yes,
transferring?
the reason, your lordship, the relevant portion of the office note, your lordship will find on the third page why these transfer orders were issued. If I may read out, your lordship, transfer order of the assistant inspectors of excise dated so and so was issued in compliance with the instructions issued by the Election Commission of India dated so and so. These refer to the earlier orders, your lordship, dated 21st December 2023 and 24 February 2024. No other consideration was adopted while making the aforesaid transfer order. In the meantime, new ad valorem levy notes came into force with effect from 1st of April 2024, White Gazette notification dated 7th of March 2024, by which the MRP of liquor in Assam was enhanced by approximately 20%. This has led to wide disparity of prices of liquor in Assam as compared to neighboring states like Arunachal Pradesh and Meghalaya. As a result, there have been widespread influx of liquor from our neighboring states, causing huge revenue loss to the state. Therefore, there is a need to place right officers at the right place in order to safeguard the revenue interest of our state. and a major reshuffle of the departmental officials is necessitated. Therefore, we need to propose a reshuffle of gazetted officials to the excise department, government of Assam. And for grade 3 non-gazetted officials, we have to effect a reshuffle. This is the reason, Your Lordship.
We don't have a one country, one liquor policy, no. When it comes to spirit, it is different.
Yes, Your Lordship. So the earlier transfer, Your Lordship, that was because the ECI demands that no officer can serve in his home district during the time of the elections, Your Lordship. There is that requirement. So the February transfer was because of that. And this transfer, Your Lordship, is because of this situation that we are facing due to influx of liquor, smuggled liquor from the border neighboring states, Your Lordship. So let them join, Your Lordship. If they have any specific grievances against the transfer, let them submit a representation as per the law laid down in SL Abbas.
To bring this on record by way of an affidavit.
Very well, Your Lordship. I'll do so.
You do it by Monday.
Very well.
Take it up on Monday again.
Very well.
Heard Mr. R. Islam, then counsel for the petitioner. Mr. KP Pathak, then it's standing counsel for the excise department, representing respondent numbers 1, 2, and 3, has produced a copy of written instructions received by him to justify the transfer of the petitioner. To stop. As per his instructions, the office memorandum dated 22/5/2002, which is relied upon by the petitioner. Said not to be applicable to the petitioner. To stop. Let this said. No, this doesn't help you.
Lordship.
It doesn't help you. This document,
Lordship.
OM of 2002 doesn't help you. You see page 36.
No written of the
Page 36 of
Read petition.
any officer.
Yes, Your Lordship.
Look at the date of this notification.
Yes, Your Lordship. Lordship will 36 of WBC 30323, Your Lordship.
Huh?
Next one.
The 3023.
Yes.
Now you see underlined directive office manager so and so. Oh,
Understand-
acha.
Yes.
4/2/2002.
Yes,
Okay,
these
okay.
two notifications, Your Lordship, are only in respect of
Okay,
this.
okay, I get it.
Yes.
This is only for non-compliance that this is issued, but
Yes,
this
sir.
original notification is of
2002, Your Lordship.
2002.
Yes.
Please
I'll-
produce that
I'll-
also.
Yes, I have them with me. I'll bring them on record by an affidavit.
The 2002 also you bring up.
Very well.
That the said document we brought on record by way of an affidavit. The learned standing counsel for the excise department says that the matter we listed on Monday is 24/6/2024. 9 to change the. Place that the matter was listed on 24/6/2024 as there is some urgency in the matter.
Yes, sir.
This fair is allowed.
Because
The interim order passed release stands extended till 24/6/2024. List on 26/4/2024.
Malata,
We send back you these instructions.
Malata, can it be 20, if he filed the affidavit on 24, then we have the occasion to file a reply, Malata.
then
No,
let
it
it
is
be
already recorded in the order. That part is already recorded in the order. but he has justified it.
Yes.
Mainly, he's saying that this is not applicable to you.
One thing, my lord, I first point out here from the input order itself, which clearly shows that this is not issued
No, there are reasons here.
Yes,
There are reasons, and there are good reasons. He has already read that before you.
yes. But here
You-
in this case, my lord, I
No,
will,
but that is
I will let
justifiable
this,
reason.
I will let this subsequently.
If the government takes the revenue into account and makes the transfer, it's a good transfer. You can't say it to be bad.
Obliged.
But the interim order continued till month.
Huh?
Interim
What is extended to them?
much of it.
Four. Four is same thing?
Same.
Lordship has Same order.
extended the interim order till 24th, my lord, and the listed matter has been directed to be listed on 26th.
Oh, no, 24th.
24.
Listing is 24th.
My lord.
4 and 5, same.
Deeply.
Item 6,
Yes.
In this case, this one was appointed Gavura also.
Pardon me?
This one was appointed as Gavura.
Yes.
Later, his appointment was challenged, and that was before the Lower Assam Commission. And by an order, his appointment was set aside. That order was challenged before the Shonda.
Now the authorities are taking up the matter. The
Not
government, they have told us that the officer has now joined, he is now taking up matters.
Not some time frame may be given because of the
No,
order.
now it will be taking up because they have assured us
Because
that they
I
are
made
taking
an
up.
inquiry before that office and I was told that their record has not come. So some time frame may be given so that matter is expeditiously disposed of.
No, you see, those are things which we can't decide. If the records have not come and you want to give us a date of completion of the hearing, can it be done? Will the order of the court be compliable order? If the records are not there, it's not there. They will call it up and do it expeditiously. Because they have received instructions from the highest authority of the state saying that what is the name? Gotmare.
Good, yes. Santanu
He has been appointed and he is taking up the matters now on daily basis. But you see, you are making a statement that the records are not there. How can I fix a date for completion?
Also, notice may be issued in this matter, let them inquire and.
You read the judgment of well, they're not required, but those are non-compliant orders. We can't take it up.
Lordship may simply issue notice and.
No, you go there, you make a representation. We permit you to make a representation before the appellate authority and they will take it up.
Yes, sir. Correct.
Mr. R. Sharma, learned counsel for the petitioner, submits that his appeal
It was not my appeal. It was by the.
which was registered as RR Appeal number 7 of 2021 was restored to file by order dated 9/6/2023, passed in WPC 1994 of 2023.
Lordship, it was appealed by the by other person.
We are not going into it, huh? Whoever has assailed is not material. This was restored. Is it right?
No, Lordship. Appeal was decided against me and I filed writ petition. That order was set
Just
aside.
let me complete the order, then tell me if I am
Yes, sir.
wrong.
That order was set aside, Lordship, not.
Please let
Yes,
me
Lordship.
complete the order and
I-
then
I'm-
tell me. Was restored file pursuant to order dated 9/6/2023, passed in WPC 1994 of 2023. With a direction to dispose of the said appeal within a period of 2 months. Full stop. The appeal was earlier disposed of by the Lower Assam Commissioner. Full stop. However, now the competent appellate authority is notified as the what is it
Director of
called?
Land Record and Survey.
Huh? DLR come Director Land Records.
And service.
Huh?
And service.
And Records and Survey, Assam. Full stop. Next paragraph. Mr. S. Dattal, and as standing counsel for the Revenue Department, submits that the that the concerned officer was away on election duty, and now he has resumed office, and the said authority is taking up the appeal. The appeal hearing regularly. Next paragraph. As the said appeal is preferred under section 162. 162.
Yes, Lordship.
Again, section 162C of the executive instructions under the Assam Land and Revenue Regulation, 1886. The court is inclined to allow the petitioner to produce a certified copy of this order along with the representation before the said appellate authority, so as to enable the appellate authority to take up the appeal of the petitioner as early as and dispose of the same as early as possible. Full stop. Next paragraph. It is clarified that the matter has not been heard on merit,
That's.
and therefore it would be open to the petitioner to raise any issue as he may so desire in the said revenue appeal. Now, anything wrong in the order?
So what I wanted to say, only one here, I have got it later also. Actually, appeal was filed by others, not by me, Lordship. And that was.
No, I have not said it was
Yes,
filed by
I
you.
understood, but
Then,
initially it was my.
so if I am disposing of without any adjudication, why should I write so much?
No.
Yes, sir.
Appear for respect numbers 2 to 5.
Oh, Mr. D. Bora, government advocate for respondent 2 to 5 is present.
Let's close.
Yes.
Item 7.
My lord, in this matter, we have received the instruction.
Yes.
That was what for my lord. My lord will issue notice. My lord will issue notice will.
But what has happened December 2012? Why they are not paying?
My lord, I will take it up, my lord. Today only.
No, but you can't do anything. You
No, my
are counsel.
My lord, no, no.
Unless, yes.
I will take it to the
Unless-
authorities, my lord, why they did not, my lord, send the.
You have seen
instruction.
today's newspaper.
I miss, my lord.
You have missed it. Or don't miss the morning papers. I don't read the news. I read only the gossip columns.
My lord.
There's a photograph of a person, Disvanovich or something.
My lord.
He's standing on a pile of notes
My lord.
on the road outside his house. He has spread over a lot of notes in front of his house. And it is being circulated in the internet. Out of that, some newspaper got it and then published it.
Not so.
So maybe here we have you.
No, my lord. I was busy with the content case, my lord. That's why I could not go through this, my lord. I have inquired with the council, my lord, early.
No, but I'll also issue a direction that they will make an inquiry and they will, in the meantime, they will disburse if not already done.
The issue here is, my lord, whether that constitutional order was passed. That is not passed.
No, you see, whatever has happened, he said that he is entitled to get salary from December 2012. So let them make an inquiry in the meanwhile.
Yes, my lord. Whether he is in service, if any constitutional order was passed, my lord.
No, correct, you are right. Because he would have retired in 2013, 13.
My lord, that is the thing, my lord. Whether he is in service.
I get it, but still once he is claiming salary for that period, you take a call.
My lord. My lord is disposing of this matter. my
No,
lord,
no, no, no.
pending.
I issue a notice.
My-
Heard Mr. J. Kalitar and counsel for the petitioner. Also heard Mr. P. Nayak and standing counsel for the PWD. For finance, Mr. R. Pujari and standing counsel for the finance department. And
also playing on the whole issue, planning council.
also Mr. D. Das, then counsel appearing on behalf of Mr. B. Sharma, standing counsel for respondent number 4. Next one. The petitioner claims non-disbursement of his salary since December 2012. It is claimed that the petitioner was serving as a muster roll worker in the GRD division of PWD and his service was regularized. But the petitioner claims that his date of birth was wrongly recorded in the service book. Next paragraph. The learned standing counsel for the PWD has raised issue of maintainability of this rate petition by projecting that if in the service records, the date of birth of the petitioner is recorded on 1/1/1953, he would have superannuated in January 2013. Therefore, there is no question that he would receive any further salary. Accordingly, it is submitted that not only the petitioner is approached after considerable delay, but he is also approached after being superannuated. Next one. Be that as it may, issue notice of motion returnable in 4 weeks. Requisite extra copies of the rate petition be served on the learned state and departmental counsel in course of the day. Next paragraph. The pendency of this rate petition shall not be a bar for the authorities in the PWD to examine the claim of the petitioner and to release, and if the petitioner is found working, to release this array which he is found entitled to. Next paragraph. List after 4 weeks.
Lordship, may I say one thing? If the Lordship, they have not passed consequential order, and as per the school certificate as well as the orders of the court, the petitioner was supposed to return in 2033, so to 32. So by the time, Lordship, if matter take up in that 1-2 years, Lordship, we have to, Lordship, just coming and going.
I am not getting you. Please repeat again.
Lordship, this as per the school certificate of the petitioner, his date of retirement would be, Lordship, on 2023 or 32. Though it is mentioned in 2012, but 20 years difference is there, Lordship, between the service record as well as his school certificate. So now, Lordship, it is in 2024, 8 years remains. And if Lordship is matter take up some more days, he has to, Lordship, just since he has not lost it.
We can't help it.
That's true, Lordship, but
We can't help it. You fix our roster. You tell us, let the bar tell us what to do.
that's true, Lordship, but
No, it's not. I'm seriously telling you. You see, when we are taking up hearing on the admission stage, we are sending off all these cases where rule have been issued and matters are to be taken up for regular hearing. Every old pending matters are getting old. And we are disposing of 22, 23, 24 matters now.
My
You
lord,
tell us, let the bar decide. You go have a meeting with the bar and tell us how to tackle our roster.
let them,
Because if I start issuing rule in the admission stage, the bar will take up arms against me.
lost. It's fine, Lordship. Let them-
Correct.
Yes.
They will have a protest outside because this court is taking up hearing matters first. Then you tell us what to do.
Lost.
You are members of the bar.
Yes.
Members are there. you take a decision in the bar and tell us.
Yes.
At least this court, if not other court, I'll comply with that.
Yes. I think examine first lordship.
Huh?
Oblige us.
Item 9.
But I apologize for interruption, my lord. So far as item 63 is concerned, which lordship has reserved for order, but I have sent that notification. Lordship will find a copy of that notification.
Okay. Print out.
Print out already
Okay.
given.
Okay.
I'm obliged.
But this re-verification of the master roll that we have done again and again, twice I think has been done.
No, Lordship.
How many times it has been done
No,
till now?
First of all, there is an order on the basis of an order in 2008 it was done, but subsequently the honorable court has passed an order. Page Lordship will find it. Page 270 Lordship.
You see, this muster roll worker, please tell us, you go to the field, take an inquiry, you ask your clients to go to the field, make an inquiry and come back and tell us, will the records of muster roll worker of 1993 available now in original? It will not be there. I'll tell you why. In the government, I don't know whether they are prepared or not. There's a rules of executive instructions. I think I have said many times. You got it?
Lordship was referring to your lordship has done some bookkeeping 2-3 days back. Your lordship was saying rules of executive business was there.
Yes.
3 to 5 years or 8 years, 7 years or 8 years.
7 or 8 years is the, but somebody must tell us because I don't have the energy to do my research reading now. I'm too tied up with the matters I have. So you see, under the rules of executive instructions, there is a time limit of maintaining records. Now, employment records. Let me tell you in a very simple way which you can understand. Now, we all know who is the first Chief Justice of Guwahati High Court, correct? The High Court is a court of record. Now, if somebody asks me what was the salary drawn by the private secretary to the Honorable Chief Justice then, we won't have record. The reason is that after the accounts are prepared, audited, it is in the consolidated form, goes to the revenue expenditure account. And therefore, those records are not required to be maintained. Now, if you ask me that you please order an inquiry of 1993, I must know where I stand, whether my order will be compliable. 1993 inquiry to be done today, after how many years? 30 years. I'll be dismissing your repetition rather than doing it. We give you an opportunity. You go have it on field, tell us 1993 records are available or not. PWD, you are appearing for PWD?
I'm appearing for Water Resource Department.
Water resource. This is muster roll in PWD. Water resource. You also find out?
Yes, Your Lord.
At 2 o'clock, we take it up. You ask your authorities at come by 2 o'clock. Tell us whether the records of muster roll workers of this 1993 is available. Original record. I don't want copies of the records. Original records are available or not. Not copies and copies of copies.
That's it. What my contention is that on 5/3/2020.
Whatever is the order, today when I am passing an order, it is 30 years old. Please tell me where I stand, whether my order would be compliable or non-compliable order.
I am on limited respect, Lordship, since the Honorable Court has on 5/3/24, Lordship, that directed the authorities to re-verify or done a re-verification work. We are similarly situated, Lordship. So my
Tell us, you see, that's not a law laid down.
Yes.
It's not a precedent which will guide us. Merely make an inquiry is something which is not a precedent.
No, my complaint
You
is
tell
only
us,
to.
I'm giving an offer. At 2 o'clock, come back. You tell us whether original record is available or not. You show us, we'll pass an order. But to make an inquiry after 30 years of muster roll. Original records, tell us, ask somebody of some person with authority.
Yes, sir.
Don't ask any Tom, Dick and Harry.
Lordship, can it be on any other day?
No, let us get the information. Once we are in the session of it, it will be hot in my mind. I'll remember it at 2 o'clock. You may not be here, we'll adjourn it, but let me have the instruction. But otherwise, I'll have tendency to forget. I'm getting old.
Such a business process.
Item 10,
Yes, Mr. Chaudhary.
Here, your lordship, what's happening, your lordship, these are paramedical staffs, your lordship. What is happening? They are advertising the post. It has been continued from 2008. Every 2 years, they advertise and conduct a competitive exam, select us. Again, 2 years at fixed honorarium. It has been going continuously till 2014, your lordship. From 2000.
SC medical, SC health. Yes.
Then 2016, they have.
No, this is by whom? This is ONGC.
Yes,
Oh, no, not required. Not
ONGC, yes.
ONGC doesn't have a standing council?
No, they don't have a standing council. They don't have a standing council.
Okay.
So thereafter, your lordship, from 2016, they went on extension of 6 months. And what happened? They directly, we have to execute document.
I'm issuing a notice right now. I'm not passing an interim order.
Yes, sir.
I'm issuing a, what you call,
Because
notice including.
your
some
lordship,
date
our
and
service
date.
is continuously 36, 2014, your lordship. That's the problem. Because that last extension, 6 months is expiring in 36, 2014, your lordship. That's my problem. Otherwise, because they may, after.
No, but you have been continuing till now.
Still continuing. They have, record is there, still continuing. But they are giving 6 month extension, your lordship. Now, after that.
No, there are reasons for that.
Yes, your lordship.
You know, this permanent employee where it can't be given, they have to do that.
No,
take
your
that
lordship,
recourse.
here what's happening? They advertise a post. It is on permanent vacancies. If your lordship see the advertisement,
Yes.
it is there, your lordship. If your lordship, the advertisement is there, it is, if your lordship see, page 48, your this matter.
48.
This is 2014, there are a lot of advertisements. ONGC Assam so and so, you are inviting for the following vacancies.
No, but contractual paramedics.
Yeah.
It is contractual. Contractual has to be for short duration.
No, your lordship, the question is whether they're contractual or not. That's the issue, your lordship. Whether they can be classified as contractual, your lordship. Because there are judgment to the effect these people are not contractual because it happened throughout India, your lordship. So that same problem is cropping up, your lordship. They are.
No, because that is everywhere.
Yes, sir.
Even now they are outsourcing. You see now you see we are Mr. Danny. Okay. How many years you have?
Your lordship, this petitioner, she has started from 2014, your lordship. But other petitioner, they are older. She has started, she's continuing from 2014, your lordship, till today. She didn't service, your lordship.
Okay, this is annual,
Your lordship.
annual contract.
No, no, not annual service. See, what
Then?
happened 2014, this lady, advertisement issued this advert which I have shown your lordship. She applied it. But she appeared for written examination, she viva, medical, she was selected. This appointment, according to them, is till 30th June 2016. Thereafter, from 2016, extension of 6 months is going on. Your lordship. And she's still continuing, your lordship. I have given a chart.
Where is the fresh advertisement?
After this, there's no advertisement. This is the last. Then I have given a chart, your lordship, in the petition. I say there is a chart, I'll show it there. Yes, I'll give it a chart.
But then you will not be removed. You don't need an interim order right now.
Your lordship, issue notice on that also.
Yeah.
Notice on that.
Because you see, if even continuing, once we say that,
Yes, sir.
then they will come against you.
Then your lordship, sir,
We'll give you liberty if you feel
in case,
certain,
you
you give one IA, we'll
Yes,
give you that liberty.
yeah. That,
Heard. Mr. Praveen Chaudhary, counsel for the petitioners. Next part of the case of the petitioner is that he is working as a contractual workman in the
No, I think
contractual
you-
paramedic.
I think I am working as a contingent worker. I'm not contractual. Two concepts are different. Contractual, there has to be a contractor. Here there is no contractor, your lordship.
No, but the advertisement is contractual paramedics.
But contractual, because contractual, if you appoint a contractual, there has to be a contractor,
No.
your lordship. Because then contract level, because that is what they, if your lordship will see.
If you, that's the point.
No, no,
Because you can always say that to lift the veil,
Yes, sir.
but then you'll have to raise an industrial dispute.
No, just that I know, your lordship. Just because that's okay, your lordship.
Because that's the issue.
That
Because once you say that, the contractual labor act will apply, and then you have the power under the act to get the lifted and treat you as a labor, as a regular employee.
yes, your lordship. But there are matters pending on that issue here also.
No, I know that. That's why you see. That's why I was asking you so many questions.
That matter, which that is the same thing. Because contingent and all this, because there is a standing order also in this.
No, there's another concept.
Yes, sir.
That concept is that once you see employment through a contractor,
Yes, sir.
then what happens is that if it's a labor contractor, then it is the contractor who will assign the job.
Yes, sir.
But if I, as an employer,
Yes, sir.
give them direction,
Yes, sir.
that means I'll be the employer.
Yes, sir.
So then you will lift the veil and say that, well, it is through a contractor, but the instructions are issued by us, and therefore they to do that. Because in I'll tell you, this we have experienced, and that's why
No,
in the court, I'll tell you, in the court we have these Sulab people to come to our bungalow and clean it.
Yes.
Now in this 5 days of 6 days of huge rain, there's a huge debris which have come into the wall from the outside, and they have blocked the entire drainage system and the field. Now we tell the contractor to send people there and clean it, but we don't give them orders. We tell the contractor to get the work done. Now, if I give direct direct command to the workers, then they will have a liberty of coming and saying that, well, I have been ordered by X and Y to do these things. So therefore we leave it and we give it to the supervisor here. We give a call to them and they get the work done. It is only to prevent these people to come up and then claim that they are under direct employment of the.
Because there are judgment of this honorable court also, where in ONGC they have held the contract with sham also, and it was upheld by Supreme Court also.
Yes, yes.
Those sets of matters I have dealt it also.
Yes, yes.
They said they are just to avoid, they have to deprive the salary, they are doing all the work. Even ONGC, if your lordship will see, almost all are contract workers because they get less salary and that the whole problem crops up. They have been working for 25 years, 30 years, they are about to retire, they are still on contract. So no, because they are giving fixed salary and they don't get the arrear salary. So litigations are there on that aspect also, your lordship. Because there's one matter which I have done, your lordship. 99, the industrial tribunal has asked them to regularize. They didn't regularize. It went to here, High Court, they lost it. Then the division went on a technical point, then it when Apex was settled and even affirmed the judgment of tribunal because on some issues it came to DB also affirmed the award also. People go again second time. Then what they did, 2019, they give them fresh appointment to depriving all those things. So these are the things which are happening. When we see, your lordship, a lot of problems are coming up, your lordship.
As a contractual paramedic, post op, she was recruited under advertisement number 2 of 2014. Post op, the initial contract was a period of 2 years. Post op, thereafter, the ONGC authorities are extending the contract period by 6 months and she's working till date. Next one. The learned counsel for the petitioner has submitted that as the petitioner has continued to serve for more than 10 years, it can be construed that the petitioner is working under a regular vacancy. It is also submitted that in guise of giving temporary appointment, the petitioner is made
If your
to work.
lordship sees page number 13, I have given a schedule, your lordship, that's already appointed.
Page
13. Details I have given, but she has also given. 13.
But that's okay, we have
No,
noted
that's I
that.
just pointed because they all the schedules are given when.
Okay. No, for various periods, do it has and just 6 months. You for various periods. Full stop. It is. It is submitted that the said method has been adopted to deprive the petitioner of a regular scale of pay to stop. Accordingly, it is submitted. There is reasonable apprehension that the service of the petitioner may be terminated at any point. Full stop. It is. Accordingly, the petitioner by filing this petition under Article 226 of the Constitution of India is seeking a direction upon the respondent authorities for regularization of a service along with arrear pay admissible to a regular employee. Next part. Issue notice of motion including notice on the prayer for interim relief returnable on. Give a date after 5 weeks. The petitioner shall take steps for service of notice on the respondent by registered post with AD, as well as by routing the process through the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing. Next paragraph. As an interim measure until the next returnable date, it is provided that the contractual employment of the petitioner shall not be terminated till the next date of listing. Look at her. I said twice, it will be last. As an interim measure, the service of the petitioner shall not be terminated till the next date of listing.
Next, connecting matters, some factual difference are there. The other matters are there, 11 also.
Or same thing?
Yeah, same thing. Only
12th of August.
So Lordship, here, so for petition number 1 is concerned, he similarly situated.
Item 11.
But so far petition number 2 is concerned, he was working from 2008, Your Lordship.
2008.
Your Lordship. That advertisement is pay NHRP 69, if Your Lordship, right? That is his
Page number
page number 69.
69.
Yeah.
Here only there will be one change. Petition number 1 is working from 2014, same.
Same advertisement.
And petitioner number 2 is working since 2008. Same one.
And rest are same. In the
And next,
third matter, petition number 1 is 2007,
petition number 1,
is 2007.
2007.
Yes, sir. And
Item 12.
petition number 2 is also that period. Just let me give it from the list of this.
Just write it and give it to the court master.
Yeah, I'll do that.
Just write it and give it to the court master.
Both are 2007, Your Lordship. 2007.
Okay,
Both are.
both 2007. Okay. Same, 2007.
Deeply opposite.
Item 13.
It is visible.
If please the Lordship.
Yes.
Lordship, this matter will be taken up on next week, Your Lordship. Matter will be taken up on next week, some
Next week we are this deep in water.
Lordship,
So much of rain.
I said because new cause of action has arrived and we have taken inspection, Your Lordship.
Here is the case we only can issue a notice. We can't do anything else.
Lordship, he has been already appointed, Lordship. He was suspended from his service, then he is appointed, Lordship. So I think these matters have become infectious, Lordship.
Infectious, okay.
Lordship may have taken up after some time.
If it is infectious, why waste time on that?
No, Lordship, there is one question is that because we have made an appeal, Your Lordship. We have made an appeal against the penalty order, Your Lordship. That appeal, without providing the copy of the appellate order, outcome of the order, one posting order has been issued in terms of the penalty order issued by the disciplinary authority, Your Lordship. Okay, for the time being, Your Lordship, I think you will argue on this.
But then this would not be a proper instruction if he has filed an appeal. What has happened to the appeal?
Lordship,
It's not a proper.
he has been reinstated and in a higher post also, Lordship.
No, but what about the disciplinary proceedings? What has it been?
That has been revoked, Lordship. The complaint has been revoked.
Complaint has been revoked.
Yes, Lordship.
But where have you stated that?
Lordship, later on, the EE Bongaigaon Water Resource Division Bongaigaon has revoked the suspension order of Sri Sanjay Kumar Das, reducing the post of head assistant to the post of senior assistant by order number so and so.
If something is wrong, either I am not understanding or you can't, suppose, I'll suppose that I can understand. Here you say, in pursuant to final disciplinary proceeding, White TO number so and so has reduced so and so from divisional health assistant to upper division assistant. The earlier order of placing Sanjay so and so under suspension is revoked.
Yes, Lordship.
That means he has been punished. He has filed an appeal. You have reduced his rank.
Yes, Lordship. But after later on, he has been
Where is that?
next order, Lordship. Next page.
You better take instructions. Next time when we are taking it up and you are restored to back to service, then even while dismissing, will impose some cost. You better take instructions. If you have been restored back to the position of a senior assistant, and then you still want to adjourn the matter and take it up after some time. But after some time, you'll be sure of cost. You take instruction when we adjourn it, that means some cost will be imposed. Issue to provide you. Yes.
But in the year 2013, my lord, there was an advertisement issued by the respondent number 3 for appointment of certain junior assistant under him. And that lordship may kindly see that advertisement page 25. Thereafter, I offered my candidature against one of those posts.
You are seeking promotion.
Promotion.
At least issuing a
But
notice.
thing is this, my lord,
Yes.
I was not promoted, where respondent number 8 has been promoted, who is a tainted person. There are so many allegations, so many so-called notice, there FIRs also against her. And she is much lesser than me in so far merit is concerned. So I had a doubt in my mind regarding gradation list. Gradation list was not given to me. And gradation, after RTI application, I got it, and I saw that my name is below her. And her husband is respondent number 7 here. Her husband was the examiner of her own papers. Husband was the examiner of wife's papers. And in my answer script, I got on RTI information, those are cut marks that are there. Cut marks are there. In one place, 1.5, another place, 1.5, all these are cut, only 0.5 is given. So this thing I have annexed here. So at present, my lord, my submission is this. Lordship may kindly see for a moment how these marks have been
No,
manipulated.
I can't do anything right now. We will only issue a notice.
Notice and answer script may be called for.
Answer
That-
script.
Yes. Kindly see page 59, madam.
59.
Yes, 59. These are my answer scripts. And operative portion, most important portion is page 62, my lord. Here, lordship, you see, here I got 1.5 marks and 1.5 marks. That means 3 marks. But all these are cut by respondent number 7, who is the husband of respondent number 8. And this I have been given only 0.5 marks. So she was, this.
Mr. Amir
matters.
Mahmood, then counsel for the petitioner, as well as Ms. D. Jain, learned counsel for the
Respondent number 1, 2, 3, and 6.
respondent number 1, 2,
3 and 6.
3, and 6.
Yes, sir.
And Mr. A. Chakravarti, and government advocate, appearing for respondent number
4 and 5.
4 and 5. The petitioner claims that the respondent number 7 was the examiner where, along with the petitioner,
Examiner and invigilator.
was the examiner for the written examination, oral test and skill test under AWRMI for promotion from the post of
Junior assistant to senior assistant.
junior assistant to senior assistant, where along with the petitioner, respondent number 8 was also a candidate, and the papers were examined by respondent number 7, who is the husband of respondent number 8. Full stop. By referring to the RTI, the answer scripts of the petitioner received by RTI, it is demonstrated that the marks are cut and overridden, which is alleged to have deprived the petitioner of promotion. Accordingly, by filing this writ petition under Article 226 of the Constitution of India, the petitioner is seeking a direction from the respondents to set aside the you want the gradation list to be set aside.
Gradation list should be set aside as well as so far and promotion of respondent number 8.
Gradation list cannot be set aside. You have not impeded everyone.
Only, no, my lord, only so far it relates to respondent number 8 only. My prayer is very much clear.
Oh, okay. Gradation list. Insofar as the seniority position of respondent number 8 is concerned, and for direction to promote the petitioner. Next, issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned state and department council in course of the day. Next, the petitioner shall take steps within 2 days for service of notice on respondent numbers 7 and 8 by registered post with AD. So the learned counsel for the petitioner is the notice is made returnable on after 5 weeks. Next, the petitioner shall take steps within 2 days for service of notice. On so by registered post with AD as well as by usual process. No, sorry, only registered post with AD. Next, the learned counsel for the petitioner is at liberty to collect the postal receipt number and to submit postal track report prior to the next date of listing. Next, the standing counsel for the Water Resources Department shall produce the
There's 18 bottom.
Shall produce the records of the written test and the interview, etc., in respect of the petitioner as well as respondent number 8, and also provide specific instructions as to whether the respondent number 7 acted as an examiner in the selection process, where respondent number 8, his wife was also a candidate. Next one, this one, so and so.
12th of August, 12
Highly obliged.
Item 15.
May I please, Your Lordship? My lord, here in the incident case, my lord, we have challenged the departmental inquiry proceeding, my lord. Because it vitiates, my lord, to draw lordship's attention, my lord. I like to draw lordship's attention, my lord. First show cause notice was issued, my lord, at page 60.
Just a moment. Okay, we are issuing notice here.
Lordship, same instruction, Lordship, I have placed in item number 14.
Huh.
13, Lordship, sorry.
Yes, you have been restored back to your post of senior assistant.
No, my lord, that we have challenged, my lord, earlier questioning. Here, my lord, we have challenged the entire departmental proceeding. That
So when
is-
they have revoked everything, what is the?
No, they have not revoked. They have imposed the penalty
No, Lordship.
without passing any appropriate order in the appeal. Just they have, my lord, after receiving the advance copy, they have served a copy, my lord, giving me senior assistant.
No, once he
Whereas
is
I'm not
producing it, once he is producing it before the court, we take cognizance of that.
My lord, I am not senior assistant, my lord. I should have been head assistant. They have done wrong, my lord. That's why, my lord, we preferred an appeal. That appellate outcome they have not disclosed, my lord. That will come later on. Yeah, my lord, in the Sten case, I challenged only departmental proceeding. Departmental inquiry, my lord. A person.
What is your instructions?
Lordship, I have placed that.
No, you have heard, Mr. Barbuya.
Lordship,
What is your
that-
instructions?
That instruction I don't have, Lordship.
Then we,
Lordship may issue notice now and we will file our affidavit.
no. You see, Mr. Sharma, you are
that-
taking a great risk. Because the courts are always unpredictable.
So what- they
And
have instructed
I am
me.
one of those people who are like pendulum. I can swing this side and again swing that side.
He has
I
been
won't have
given the post of
consistency in my
senior
thought process. Because you can take an exception to your producing of this record also.
Yes.
Who has given this record? Who has given to you these instructions?
Lordship, from the department it has come. I have mailed this from the department it has
No,
come.
I understand. Who is the person who has given you this? Somebody must have sent you. ABC. Who has sent you this?
It deals with all this case matters. See, if there is a
Pardon me?
there is a person who deals with this case court
What
cases.
is the name of that person?
Lordship, exact name I don't know.
We'll call him at 4 o'clock. Ask him to be here. Whoever is that person who is giving you that record. Personal appearance of that person. At 4 o'clock.
Lordship,
Wherever he is.
Lordship, he has been posted in senior assistant post, Lordship. He has, that complaint has been revoked, his
He
discipline.
says that it is different. You see, I don't know. I have not come from clerk to
Lordship.
junior assistant to senior assistant to reach here. I've jumped. So therefore, I don't know what is the reality. He says that senior assistant and head assistant are different cadre.
Yes.
It may be same rank, but it is higher in position.
Then Lordship, I will take instruction, Lordship.
At 4 o'clock, ask him to be here.
Lordship, I will take instruction, Lordship.
No, no, you see, they give you a wrong instruction. We can take an exception to it. They want to mislead the court through you.
Lordship, let me take
No,
instruction
no,
today,
no,
Lordship.
at 4 o'clock, ask him to be here. Personal appearance of that person. Let him be here at 4 o'clock.
Lordship, I will take instruction. Please, Lordship.
No, no, you see, after you see, somebody must bail a cat.
Yes, Lordship.
Now, who will do it?
Let me
How
take
how
instruction,
could they
Lordship. I
give
will-
you an information which is incorrect?
Lordship, may kindly give me half an hour. I will take the instruction, Lordship.
Okay, at 2 o'clock.
Obliged, Lordship.
Both the matter, my lord, 13. Look.
17.
My lord, my lord, the transfer matter, my lord, petitioner, my lord, now, my lord, from transfer, my lord, to present place of posting at the Guwahati frontier, my lord, to my lord, Rani Danga, my lord, 51 battalion. My lord, what happened in this case, my lord, the petitioner, my lord, himself, my lord, he is a disability, my lord, and his brother is also, my lord, disabled, and as well as, my lord, his wife, my lord, also. My lord, kindly see, my lord, the disabled certificate, my lord.
Where is that?
This, my lord, petitioner's brother, my lord, page 41, and petitioner himself, my lord, I have a next, my lord, and page 32 now. Entire family, my lord, medically, my lord, some problem, man. So, my lord, in this regard, my lord, he, my lord, give undertake, my lord, in his representation, my lord. That, my lord, he will go to, my lord, the VRS, my lord. His wife also, my lord, is suffering, my lord, lots of problem, my lord. Now, my lord, his weight, her weight, my lord, is, my lord, only 38 kilograms.
No, but ultimately, you see, it's a transferable job. You'll have to accept a transfer.
That is correct, my lord. I am not, my lord, continue my present place of posting, my lord. I am now, my lord, I have stated in 1st Battalion SSB, my lord.
Pardon me?
1st Battalion SSB, my lord, in representation, my lord. It's a Hunapur, my lord, and the frontier headquarters Guwahati from present place of posting reputation. I am ready to go, my lord.
Where is the transfer order?
Transfer order, my lord, page 54, my lord. It is 10th April 2024. Petitioner's name, my lord. Page 55, my lord.
55.
55 is the petitioner's name.
Serial number?
Serial number, my lord, 20485, my lord.
20485.
Lordship.
Where is this 41 battalion
41
located?
battalion is, my lord, Rani Danga, West Bengal.
Yes.
Lordship, he is here since 2019, Lordship, almost 5 years. Now, Lordship, there is a policy, Lordship will find he has annexed that to the reputation, Lordship. Page 105. Lordship may come to 106. Serial number 5, tenure. Page 106, Lordship, serial number 5, tenure.
Yes.
All units and formations 3 year except battalions as high altitude, Lordship. So normally it is 3 years except for the high altitude, which is for 2 years. And Lordship, clause number B, on completion of tenure in a unit of particular frontier, the personnel will be transferred to another frontier. Now, Lordship's frontier, everybody wants to stay in the frontier because they are the soft posting, Lordship. So we have to accommodate someone else also who had been in the high altitude. And moreover, Lordship, so far as his wife is concerned, Lordship, all the documents are from Orissa. Perhaps
Definitely, why not? What is wrong?
So she's not undergoing treatment as Guwahati, at least, which we have stated. So nothing has been enclosed with that.
No, you see, I may be, one may be transferred from one place to another place, but I may have faith on a doctor.
Lordship,
You see, wherever I travel,
Lordship.
I call him. call the one doctor you know well.
Lordship.
I call him and take his advice.
That's true, Lordship. But all the documents that has been pedagogic treatment has been annexed from Odisha, Lordship.
No, but
So he
that's
has
just not a,
already 5 years here, Lordship.
that's not an issue.
And it's a normal all India transfer, Lordship. There is various persons has been transferred. Of course, some has been some considered, Lordship. That's true that depending upon the
No, but if in his family, three people are themselves di- physically challenged.
Lordship.
Because as caregiver,
Lordship.
those that place, can you inquire? It's a family
staying on-
accommodation or not?
Those places.
This 41 battalion where he's transferred,
Lordship.
is it a family accommodation?
That I have to take in.
No, my lord, it is a totally, my lord, battalion, my lord. Battalion and my lord, frontier is a different, my lord.
No, I don't know. I have no personal experience. I'm asking you whether it is a place where family quarters are available. Because if it is family quarter, then the entire family can be settled. But if it is only a what you call barrack quarters, then you'll have to accommodate him in a
Lordship.
family.
Lordship, in normal cases, Lordship, they allow the family to stay in the frontier for 3 years.
No, I understand, but he's a special category person.
Lordship. No,
We have a policy.
we allow the family to stay. If the person goes outside the frontier area, Lordship, normally we allow the family to stay, Lordship.
No, but who will give care? Under the Persons with Disabilities Act, caregiver has to be there with them. Then
Lordship, let me take instruction whether there is a family accommodation or not.
by when?
Monday.
Monday. Till then, don't take coercive action against the petitioner.
Already release order, my lord, has been issued, my lord. Already release order has been issued.
Okay, for 1 day, we give you that protection. The judgment of 2022 in Supreme Court for the personnel in defense and the stay orders should not be passed. Whatever be the, as for the armed forces and well, Mr. Alan Dingyal and counsel for the petitioner, as well as Mr. B. Chakravarti Leonard, CEC appearing for the respondents. Next, the petitioner claims that he, his wife and his dependent brother are all specially abled. And therefore, as a caregiver, the petitioner is liable to stay with his specially abled wife and specially abled brother. To stop. Next, the learned counsel for the petitioner has submitted that the petitioner has been transferred from FTR HQ, FTR headquarters,
Frontier headquarters,
Guwahati to 41 battalion. So it is submitted that the set place of posting is not for family accommodation. And accordingly submitted that the petitioner is ready to accept a transfer where it is possible for him to take care of his specially abled wife and brother. First off, it is submitted that as per the policy of the respondents, persons suffering disability are not subject to a routine transfer. Next paragraph. The learned CEC submits that some time be given to him to obtain instructions and to address the court. Stop on his prayer. Next paragraph, on his prayer, that the matter will discussed on in the motion column on 24/6/2024. Till then, the transfer order petition shall not be enforced.
Is it, my lord, on next Wednesday, my lord? Next Wednesday, my lord, instead of Monday, my lord.
Transfer orders are very difficult. You'll not be here.
Some my personal problem, maybe my some personal problem, my lord, on Monday.
Okay, Wednesday.
Thank you for 26.
26. Supply item 68.
What is the date of the order?
Date of the order is 19/12/2023.
Okay, contempt. This is SB Chaudhary, counsel for the petitioner, 19/12/2023. Take steps by 2 days. Returnable on 5 weeks. Returnable on so.
12th of August.
Tendency shall not be a bar.
Item 69.
May I please, your lordship? What's the matter pertains to the transfer of petitioner, your lordship? The impugned transfer order, your lordship will find at page 25 annexure.
My lord, if I may produce the instruction, or the petitioner has already been relieved from the unit, my lord. He is already relieved.
The movement order has been issued yesterday. Lordship, in fact, the matter was listed before this honorable court on 19, your lordship. That the matter was deferred.
এই চন্দ্রকায় বানিয়ে চলিছে এক্সট্রা মস্ত আবাই চন্দ্র
He has already accepted the movement order, my lord. He has put his signature.
He has not joined in the new place of posting, your lordship. The break journey is there. 20 days remaining for his joining there.
What is this home sector?
Yes, my lord, his home sector, that is the 4th tenure. He is in the state of Bihar, your lordship.
Your home is at Bihar.
Yes, he's now his home sector tenure is due. Because he is in the last part of his service, that is 4th tenure, your lordship may find at page 32. 32 of my read petition. That is CISF circular. Operative portion at page 32. At para 12, tenure of posting, your lordship. Small a, first tenure 7 years, second tenure 12 years home sector, first tenure out of home sector, third tenure 6 years out of home sector, your lordship. Now 4th tenure home sector, your lordship. Altogether 6 and 7, 13 years out of home sectors, and petitioner has completed more than 13 years. He has completed 16 years of service in the out of home sector, your lordship. Now his posting is completely due for the home sector, lordship. And in this regard, at page 45, annexure D.
When are you superannuating?
12 years remaining, your lordship.
So out of this, you say 10 years you have already served in your home tenure.
Yes,
Or home sector.
yes, my lord.
So you get only 12 years in the home sector, and then remaining 4th tenure will be home sector. You still have time.
My lord, we'll see page 33. Page page
No,
30.
let him complete, then
Yeah.
we'll hear you.
My lord, before that, may I take your lordship to page 45?
Page 45.
Yes, my lord, that is an extra D. That is a representation. Willingness for transfer in home sector, my lord. Actually, prior to that,
No,
actually.
that's okay, but these things are only they are asking you for that. It's not that once you ask, they'll have to give it.
Because
not
that
bounded.
time, normally what happened at the last part of his tenure, he may give unwillingness also. So for the year 2022, so far inter-sector transfer was concerned, he gave unwillingness because of some domestic problem. But in 2023, he just presented his willingness. He requested the competent authority for his posting to the home sector, my lord. Since in 2023, he was not posted, but in 2024 also, so far inter-sector transfer is concerned, he has not been earmarked for that. So far guideline is concerned, my lord, some domestic affairs are also there, the marriage of his daughter. And from ASC Bhopal, that is 100 kilometers away from his state, my lord, from his native place.
We issue notice, you join the place of posting and then we'll consider.
Lordship, only 20 days remaining, my lord. And my lord, he submitted representation just.
No, that's okay. Once they have released you, we issue a notice.
The
we'll
representation
consider
is
that.
due for consideration, my lord. So till then, my lord, your my lord may please to
No,
give direction not to give effect to the
not after that Abbas's case.
release.
Once they have released you, join and then we'll consider.
Yes.
But Mr. D. Boral and counsel for the petitioner. Agreed by the order of transfer. Dated 10/4/2024.
Lordship 12 for annexure.
12/4.
Yes, my lord. Annexure B is 25. Service order number 21/2024.
Okay, service order number 21 of 2024, dated 12/4/2024. No, this is not a transfer order.
Lordship, this is final transfer order, my lord, pursuant to the earlier order. 10 April 2024, that was the sector.
Transfer order is annexure A. Then you gave a representation, then it was rejected. It's a
Not,
rejection.
my lord. Pursuant to that order, my lord, the subsequent order that is page 25, that order has been issued. Allotting their unit. Lordship will find at page 28,
20?
serial number 298.
Okay, acha. The
Yes,
transfer order number so and so. Oh, sorry, service order number
Yes,
21 of 2024, dated 12/4/2024, by which the petitioner was posted, was transferred from which serial number?
Serial number 298, your lordship.
From
NRL
NRL Numaligarh to ESG Bhopal has been challenged by the petitioner by filing this writ petition under Article 226 of the Constitution of India on the ground that the petitioner was entitled for a home tenure posting accordingly. It is submitted that the posting outside the home sector has infringed his right to continue at the, continue for 12 years in home sector in the second tenure in terms of the circular number 22/2017 dated 25/9/2017. Accordingly, this declaration has been filed on Article 226 of the Constitution of India. Next paragraph. The learned CGC has produced a copy of communication dated 21/6/2024 by which the which the petitioner had been relieved from CISF unit NRL Dumarigar on 26/2024 and a movement order to proceed to ASG Bhopal was also issued. Next paragraph. The learned counsel for the petitioner submits that the petitioner has 20 days.
Yes.
20 days to join the place of posting. And accordingly, he prays for a interim stay of the transfer. Next paragraph. Issue notice of motion, including notice of the prayer for interim relief, returnable on. Give a date after 5 weeks.
Lordship,
August.
regarding the representation, Lordship, regarding the representation, two representations submitted. May not be, pendency of the representation may not be barred for considering the representation.
Okay. The requisite extra copies of the requisition be served on Mr. H. Gupta and at CGC who accepts notice on behalf of all the respondents. Next paragraph. The pendency of the writ petition shall not be a bar for the Director General, CISF, or any other competent authority to dispose of the representation of the petitioner. It is page 46.
Yes, my lord, 46 and 47. Two
Within bracket,
representations.
annexure E and F of the writ petition. Next, the respondents are put to notice that the joining of the petitioner at the new place of posting shall be subject to further orders that may be passed on the next date of listing. But once you have this policy, why don't you adhere to it?
My lord, this has to be as per the vacancies, my lord, page 33.
No, but you see, once you, it's not that your authorities, Director General or Ministry, who has
No.
formulated this policy, had
No.
no wisdom. Either you'll have to tell us that they had no wisdom. Your assistant commandant has more wisdom than that. The authorities
representation-
take a decision and you flout it, and then you say that it is army, it is uniform post. You create litigations. You could have a redressal mechanism so that people can settle their cases there.
No.
They are multiplying litigations.
He served 3 more years, my lord.
Yes, Mr. Mahato, this is not a objection.
Sorry to interrupt your lordship, because at 2 o'clock I will be out of state.
No, it's okay.
But that is already complied with. Your lordship can close it, my lord. But he says that already has been paid, my lord. I believe him, my lord. It will close, my lord.
Only 3-4 left because of their legal hair certificate. Some of.
Then, my lord, that means, my lord, the judgment passed by the honorable has been complied.
Compliant. I have written the petitioner number in side blue.
Petitioner number?
1 to 53, lordship.
Okay. You know what you have done? Yes, you know, you're aware of it. Then I should not say anything more. You have created a circumstances where you have distinguished people who have come to court and those who have not come to court. Article 14 is directly violated. You say that VRS to those petitioners who have come to court.
No. Others also.
No, I don't know.
No, lordship.
why-
Petitioner number.
Question, my lord, your lordship, this is judgment in RAM. This is not in personam.
No, whatever be.
My lord, yes.
Some
that-
persons in this list, lordship,
No,
who
that's
are
okay.
not petitioner also, they also receive lordship.
No, that's okay, but
I have only written that these
at
petitioners
times,
in
at times
blue.
we read more than what is required to be read.
My lord, correct.
In English, we call it reading between the lines.
My lord.
Just putting it on notice, it will be a great difficulty. Mr. T.J. Mohanty and his senior counsel, assisted by Ms. A. Bora.
Yes, she now, at present, she is assisting, my lord.
Oh, sir. So I'll record your name.
My lord.
Huh.
Her name.
Miss T. Sharma. Learned counsel for the petitioners has submitted that Mrs. R.B. Bora, learned standing counsel for the
Lordship, I have
DTC
appeared.
and learned counsel for respondent number 4 has produced a copy of instructions to the effect that all the petitioners were provided additional VRS dues payable to the employees in terms of order dated 27/3/2014 and Supreme Court order dated 7/11/2023. Stop. The next, the learned senior counsel submits that he has accepted the version of the standing counsel for the respondent number 4 and has no objection if the matter is closed on
My lord,
satisfaction.
deeply
Stop. The instructions produced by the learned counsel for respondent number 4 is kept as a part of record. To stop. On compliance of the order of this court, this contempt petition stands closed.
Deeply.
After how many years, Mr. Mohanty, you are getting this?
Long, my lord. That they went up, there's a writ appeal, they went to, they the first they filed a review.
Which year?
That, my lord,
VRS of which year?
2008.
2006 notification, 2008.
2008.
2008.
Most of them, my lord, probably now, at least 4 or
Expired.
5 already expired.
Petitioner.
That's why, my lord, probably.
Okay.
Legal hairs receive.
Item 18.
Yes.
May I please, Lordship? Lordship, I'm on behalf of my senior, Mr. Govind Chandra, Lordship. Lordship,
Yes.
I have for Lordship, complaining party responding in contempt case, Lordship. Lordship, the opposite party is presently holding the post of the respondents, Lordship.
No, where is the notice to them to comply with the order of the court? For contempt, there must be willful violation.
Lordship.
A new officer coming may not know about the order. You have to give
Lordship,
them to notice.
Lordship, the opposite party, number one, had submitted the order to the opposite party number Lordship 2 and 3, Lordship.
Where is that?
Lordship, letter is annexure 1, page number Lordship 8, Lordship. Can you-
Okay. But Mr.
I mean,
Ahmed, non counsel for the
Lordship.
Amin,
Amin.
non counsel for the applicant. And Miss,
I'm appearing on behalf of Mr. S. Bora.
your name?
J. Rajkumari.
A.
J. Rajkumari.
J. Rajkumari, non counsel appearing on behalf of Mr. S. Bora, counsel for respondent number. You're appearing for whom?
1 and 2 of the contempt.
Okay, respondent number 1 and 2. Next paragraph. By filing this interlocutory application, the petitioner seeks to implead the opposite parties number 1, 2, and 3 as respondent numbers 3, 4, and 5 in the connected contempt petition. Full stop. By referring to the documents annexed to this interlocutory application, now it is submitted that the said opposite parties are aware of the requirement to comply with the order dated 11/6/2018, passed in WBC 4635 of 2017. Full stop. Next, this interlocutory application stands allowed. The opposite parties number 1, 2, and 3 are permitted to be impleaded as respondent numbers 4, 5, 3, 4, and 5 in the connected contempt petition. Full stop. The petitioner shall provide a freshly typed cause title in the connected contempt petition and submitted before the AOJ contempt section. Raji, contempt section. Contempt section would incorporate the cause title in the said contempt petition and thereafter list the matter before the court. In the contempt petition, you write, in view of order passed today in the of the contemner and respondent 1 and 2 present. In view of order passed today in the connected IA Civil 1722 of 2024, impleading of opposite parties therein, respondents therein are permitted to be impleaded as respondent numbers 2, plus 3, 4, and 5. So let the matter be listed after the amendment of the cause title.
Item 19.
I believe, Your Lordship. My Lord, in earlier occasion, My learned friend, short time to obtain instruction from the newly implemented respondent number 5. That is the chairman at SLC from 6 years. And amended posted also my lord filed my lord.
I did not get you. Please repeat again.
Oshiba, so far my lord, order dated 26/6/2023. The instruction was sought for by the learned government from the newly implemented respondent number 5, the chairman SLC from 6 years. And matter, my lord, relates for die in harness case, my lord. And
Lordship, perhaps by that time, my colleague who appeared on that occasion, he was not aware of Devoto Tiwari judgment. After the Devoto Tiwari judgment, I think this whole issue is otherwise settled, Your Lordship.
What are the relevant dates here?
my
Yeah.
lord,
Died in, husband died in 2016.
died on 29/2/2016.
9 to
29/2/2016.
16, yes.
Page 24. my lord.
Yes.
And representation also made on 23/9/2016.
23/9,
2016.
16.
Yes. And now, my lord, impugn order passed on
31/12/2018.
Yes.
SLC manuals.
page 29, my lord.
Page 29.
11 January 2019.
It's 31st of December 2018. The SLC.
No, what is the DLC decision date is available now?
Yes, my lord. Page, my lord, 31.
No, just give me the date. DLC meeting dated.
DLC date is not here.
It's not available. Okay. 31/12/18.
Meeting was held on.
The meeting was.
Where is the serial number?
Serial number, my lord.
330. Page 30.
Page 30. Serial number, my lord, 15. Srimati Jayanti Medi. Reason shown, my lord, applied after Syed Imamul Ahmed, but a single admissible vacant post.
What does it mean?
On the right side, my lord.
What does it mean?
The serial number 1 on the earlier page, page 29. The person, Syed Imamul Ahmed, was appointed against one single particular vacant post. And the petitioner's name is at serial number 15 on the ground that the petitioner applied after Syed Imamul Ahmed for the single admissible vacant post. That was the ground of
No,
rejection.
that can't be. It has to be set aside.
That was the ground of rejection.
It can't be. It has to be set aside.
Be that as it may, Your Lordship, based on 7.5 of the Devoto Tiwari.
No, but still, this is a wrong decision.
Yes.
That the Tiwari will not come in.
Your Lordship, then he has to make that particular person also a party in this writ petition. He has not been
He'll
made
be
a
affected
party.
now.
He'll be affected. If it is set aside, Your Lordship, then that
Oh.
Syed Imamul Ahmed has to be made a party.
Otherwise, it will become behind the back. my lord.
He is right now working there in PW department.
This man is not a party here.
No.
No, Lordship, I am not against the Imamul Ahmed.
Then you can't get a post. If it's a single post and somebody has been appointed.
If, my lord, new
Where
post
will it
arise,
Hmm?
if new post arise thereafter, then on that.
It is not a right.
Against
Your
that post,
Lordship.
I am to be adjusted.
No, you tell us the law. In compassionate appointment, you get appointed on a vacancy which arose on the date when your husband died.
Lordship.
If there's only one single post and somebody is appointed, in 2024 vacancy, you can't be accommodated.
As in the Devoto Tiwari judgment said that it's not a case of inheritance. That one.
No, not that.
No, that is
But
not-
you see, you are considering, SLC is considering, there's no policy that first come, first serve basis will be taken up. Then you don't need that SLC. It could be given to a computer and they will do that combination and come out with a correct, what you call, permutation and combination.
Yes, Your Lordship.
Only, yes, my lord, only that post, they have to be removed. And
Because we have
Who is
written to
now
them,
coming?
we have written to the SLC, that staff officer of the chief secretary, asking the ground on which this particular decision was taken. We
No,
have
that's not received- required. Once you say that, that means you adopt a policy of first come, first served basis.
I agree.
But then that is not a standard applied anywhere.
Very-
First come, first served.
But this
But my
particular
lord, yes, that
person,
has to be hard. That is only the one.
that is the only difficulty otherwise. If your lordship
On-
set aside, then
On last occasion, my learned friend said that SLC is not party. And therefore I made party the one court
No, you
also
see,
implemented.
no, you see, every time we read, we may come up with a different question. Does not mean that after you hear us, then you amend your petition.
Necessary, I may
Today,
also
today
make
we are,
party.
today we are thinking something,
Yes.
tomorrow we may think something else. But once
I'm-
they are showing that it is on a single admissible vacancy, and it's not a party, and you say that you are not challenging his candidature, then we have no other option but to close this writ petition.
No, I will make party money. So I will implead him.
Hmm?
I will implead him.
Okay. On the prayer made by Mr. K. Bhuyan and the counsel for the petitioner, the matter stands adjourned today. Mr. D. Vora, learned standing, the government advocate
4 and
for respondent number 4 and
5.
5, and Mr. Ardhar, standing
one and
counsel for respondent numbers 1, 2, and 3 are present. Just after answering invitation. Do whatever you want to do. Resume after.
One line maybe quote my lord, the Inamul Haq is to be made party.
No,
That's as per number
you
6.
file an application. We can't do like that.
Lordship.
The petitions are dismissed. There's an observation of the court that the forest department should be well advised to frame rules to deal with minor minerals which are exclusively under their jurisdiction or area under operation. Such a rule would go a long way in furtherance of one of the government goals of achieving ease of doing business in the state, and would provide clarity to the stone crushing units and persons dealing with stone. Yes, item 9.
Lordship. Lordship, we have 9 master roll workers, Lordship, at present who are working. At present. 9 master roll workers,
9 master roll
only
workers.
9.
You see this. You see, the prayer here is re-verification of the master roll workers
Lordship,
in terms of the order of this court of 5/3/2024.
Lordship.
The question which I was asking was, is there any record of the original record of the master roll workers of the initial term 1/4/1993? Is it available?
Lordship, it is not available with the department at present, Lordship, means we don't have the records. But it is, means that since the petitioners are claiming that they are being employed, so obviously they will have their appointment letters and other related papers, job related papers with them, Lordship.
But please come here.
Lordship.
You are relying on the judgment of this court.
Lordship.
Come to page 284. But you have allowed this order to attain finality. Here there's a 288, you see there's a observation. The petitioner claims that they were engaged after 1/4/1993 and had completed 5 years.
Lordship, in this order, I was there, Lordship, and I have submitted my submission before the Honorable Court. In that case, we have submitted our affidavit clarifying our stand, and we have stated that only 9 workers are there at present working. And
But
beyond
you have
9
not filed any appeal against this order.
Lordship.
You have
No,
accepted this order.
in this order, we have been directed to re-verify, Lordship. So verification process is going on, Lordship.
No, but you see, you are taking a stand which is unacceptable. You say that the original records is not there, and you say that the re-verification is going on. How will you do it?
Lordship, because of which, Lordship, we have directed the petitioners to produce the relevant documents, Lordship. If they
No,
have
let
any.
us say
Because-
I am very good in manufacturing documents. I produce 101 documents now.
Lordship.
So what do? How do you verify cross-check?
Lordship, let
I'm
them,
producing I'll produce by evening. I can give you
Lordship,
10 appointment orders.
Lordship,
I just have to ask my secretary. She will draft it and give it to you within some time.
but it has to be original one, Lordship. We are asking for the
We will
original,
give you the original ones.
Lordship.
In 1993, who was the executive engineer? Even you will not know.
Yes, Lordship.
I'll put some signature and give it to you. I'll
Got
say I am manufacturing it. I'm not saying I'm producing an original one. I say that I will be manufacturing one and giving it to you.
And projected it to be
Now,
original.
how do you verify? In 1993, who was the executive engineer? Who was the superintending engineer? Those signatures would not be known
No.
to people now.
And yes, Lordship.
Then how do you verify?
Department has taken the stand to re-verify, Lordship. That is up to the department how they will verify, Lordship.
That's in fact a role of master rule.
Then
officer
if you are
to
doing the
maintain by-
verification, then you do for them also.
Yes, Lordship, we will.
Because Lordship,
Because-
they have published on the basis of this.
No, it can't happen. Mr. Datta, your stand is absolutely unacceptable.
Lordship, but in fact, this is the notice issued by them. The master rule workers, Lordship, ledger is with the executive engineer of the division, Lordship. In some other cases, forest department, even I have annexed the ledger book. It is of before 93. In a particular format, they have maintained the ledger book. And this is the advertisement, Lordship, in terms of the High Court's order, Lordship. This is issued by the executive engineer. Then process is going on.
No, but what is your document here? You perhaps you have to satisfy that this is the
Yes.
continuity of the documents in a writ petition. No, that is one part. The advertisement is one part. Now, please tell us any document by which you can privacy establish that you are working.
Lordship,
You must be in continuous service.
from 93 to 2000.
Correct. You must show that you are in continuous service.
Lordship, I may be allowed some time to bring it by additional affidavit.
Because perhaps that's why we have not heard you, but we asked the question as to whether the orders of the court will be implementable. Now, from the submissions of Mr. Das, it appears that the orders would be unimplementable. They don't even have the original records.
Yes.
And they want to do that exercise.
I may be allowed to
That
bring
means
the document.
they will now get a handle to appoint people. They will accept some, they will reject some. Hundreds of people will be given appointment. Therefore, order of the court will give rise to illegality.
So at this stage, Lordship, Lordship will allow some time. I will bring the
Okay.
documents.
On
Which
the
are
chair,
available.
Mr. U. Datta and counsel for the petitioners. Matter stands adjourned today. Please start answering summary petition. Mr. R. M. Das, and standing counsel for the Water Resource Department is present. We're not saying anything. We're not saying it.
How late?
Item 13 and 15.
Mr. Hazarika, you are also there in the matter? Mr. Hazarika, you are also there in the matter?
There is a personal department.
Okay. Okay. C. Hazarika for
2 and 3. For now, 2
this
and 3.
conference is also present. Okay. Yes.
Your lordship.
No, you have to do instructions.
Lordship, what happened, Lordship, as per my instructions which I have received, Lordship, the petitioner had earlier also filed a writ petition, after that writ appeal has been filed, where the Honorable Court had directed the Water Resource Department, because earlier petitioner was demoted to lower division, means junior assistant, from junior assistant. At that moment of time, that order has been.
No, those things are passed. We
Yes.
we gave you a specific query. And you must have got the code query.
Yes, Lordship.
So what is
He
the
has-
response to that?
He has raised an appeal, Lordship. That appeal has already been disposed of, and regarding the disposal of the appeal, petitioner has already been intimated, Lordship. As per my instructions.
Whereas they don't give you documents, why? They are taking a risk by giving incomplete instructions.
Lordship. Lordship may fix the matter on Monday. I will bring the relevant documents, Lordship.
Okay. What is presented on the prayer made by Mr. Aram Das, Counsel for the Water Resources Department, list on Monday.
My lord, instead of Monday, my lord. Wednesday, my lord. Instead of Monday, my lord, lordship kindly fix it on Wednesday because already list has been out, my lord. And there is I'll be preoccupied, my lord. That's why only one day, my lord. Whether Tuesday or Wednesday.
Okay.
Wednesday.
No problem.
Don't let them give incomplete instructions.
Lordship.
When the mood changes, you won't know.
Yes, Lordship.
The first impression is that they give you incomplete instructions to mislead the court.
Yes.
Okay.
That will be very dangerous if we start disbelieving the lawyers at the treasury side. It will be a very bad day for the court.
Lordship.
Because we tend to have so much faith on you that we,
Lordship.
at your submission, we were inclined to dismiss the petition.
Lordship.
We even threatened Mr. Mohan to be ready for imposition of huge cost. Correct. So when the mood swings, we don't know.
Lordship.
And we are doing a judicial exercise. We are depending on you, and then incomplete instructions are coming.
Lordship.
You would have called Mr. Sharma. We told him that we will call your officer at 4 o'clock.
Lordship.
They should not do that.
Lordship.
They
And-
give you 3 papers. They can't give you 4th.
I'm sorry for that, Lordship. I'm sorry.
No, don't be sorry for that. You are taking the blame for a wrong committed by your staff, and you don't give the name of the staff. Why so much eager to protect them? Can it be acceptable that you get an instructions incomplete and we leave that man high without any remorse?
Lordship. Lordship.
You give us the name. You must give us the name.
Lordship may give me 1 day time, Lordship.
No, giving you 1 day is, you see, you can't take an instruction from Tom, Dick and Harry.
Lordship.
You took instructions from someone who is a man of authority.
Lordship.
Please disclose us the name who has given you instructions. Because if you pen down in the judicial side, it will be harming your career.
Lordship.
Because I would just say that we disbelieve Mr. Aram Das for producing incomplete instructions.
Lordship.
And then every court will question you.
Lordship.
You don't want that to happen.
Lordship. I understand.
Then please tell us the name of the officer. We'll call him personally.
Lordship. It is, we have received the instructions from the law section, Lordship.
From the law secretary.
Law section.
Law
section, Lordship.
Law
Legal cell.
section.
Legal cell.
Entire members of the law section will be personally present on the next date.
Legal cell.
Legal cell, okay. For providing incomplete instructions to their learned standing counsel from all the personnel in the Water Resource Department associated with legal cell shall be personally present on 26 2024. Full stop. Their personal appearance will only be dispensed with if, no, don't say anything, personally present. Next, the learned standing counsel for the Water Resources Department shall communicate the order to the Chief Engineer, PHE, to ensure the presence of all the personnel from the law section for their personal appearance in court. List on 26/6/2024.
Chief Engineer Water Resource. Lordship.
Hmm?
Chief Engineer Water Resource.
Chief Engineer Water Resource. Okay. I'm sorry.
I will.
Huh? 13 and 15 same. Well, in 15, you don't have to write this personal appearance again. In one, this will be over. That will be the change. 21.
Finally, there is the order that the 5-6 months.
Yes, you got instructions?
Yes, yes.
What does it say?
Well, I'm passing it. to you.
We have sanctioned the amount. It will take some time. We had done it for 1 month. Let us see what happens. Okay. Mr. K.R. Padgiri and counsel for the petitioner is present. Mr. S. Dattal and its Handy counsel for the PNRD department has produced copy of letter dated 18/6/2024, informing their standing counsel that the compassionate family pension of the petitioner has been sanctioned by the order dated 15/6/2024. And on money being released, and on deduction of the GIS subscription, for the sanction of GIS shall be processed thereafter. In view of such instructions, which are kept as part of record, list on, give a date after. How much time it will take?
It will take 1 month minimum.
It will take 1 month. List
If you go to AG,
after 6 weeks, give a date. List on Spencer.
August month did it?
We are listing it after 6 weeks. Since it's pension matter, we are giving a fixed date.
19th of August, 19th.
Mr. R. Dhar,
19 August.
you are as government advocate, senior, additional senior government advocate for respondent who is present.
Obliged.
23.
Please, your lordship.
Yes.
The respondent number 2 has filed an additional affidavit in opposition. We may be granted some time to file the reply.
Okay, what is your instructions?
But I have already filed additional affidavit, my lord. My instruction is that, my lord. Lordship may kindly take my affidavit, my lord.
Yes, it's there.
After the
You
last
see,
order.
you are merely saying here in your reply that you are examining the claim.
Yes, thereafter we have filed additional affidavit, my lord.
Or is it?
Yes, yes. For that only they are seeking time for reply.
There's no additional affidavit here.
Already.
Ready to file it.
It has been received by us.
Before the.
Oh, yes, yes, it is there. What is your stand now?
Stand, my lord,
This is,
we
I have
have,
not read.
my lord.
Yes.
Paragraph 10 may be seen, my lord. This is the report from the video. Paragraph 10, salary drawn statement along with copy of the acquittance roll in respect of Sri Sophia Roman is sent, my lord, along with the reply. And there is no record of going on retirement in respect of the Sophia Roman, and his service book has not been found in the block office. So his service book is missing, my lord. And number 3, my lord, then there was no departmental proceeding for unauthorized absence, my lord. And moreover, my lord, lordship may kindly come to page number 12, the paragraph 12. Paragraph 12 may be seen, my lord. This is a
Yes.
list, my lord. And for a pension, my lord, to get a pension, this is the list that these documents are required. And those starts with those star marks, my lord. We have star marked before the particles, my lord. The petitioner have to submit, my lord, along with the, because our stand is that, my lord, petitioner never approached the authority, my lord, for his pension proposal, my lord. There are some rules for the petitioners also, my lord. They have to supply some documents and some photographs and everything, my lord. So at this stage, my prayer will be, my lord, that lordship may direct the petitioner to submit these documents, my lord, so that we can consider his pension proposal, my lord. As these records are not available in the department, we are not able to consider his pension, my lord.
What about page 34?
This is just a simple prayer, my lord, but.
No, that is okay. He made a prayer.
But thereafter.
But where is your record of giving notice to give documents?
My lord, his competent authority is the commissioner only, my lord, not commissioner and secretary. So in the commission, the appropriate authority he never approached. Even lordship will find in my additional affidavit, we have in each and every letter, we mark the petitioner, my lord.
Mr. Datta, half of the things I can't appreciate.
My lord.
The reason is you come to your affidavit.
My lord.
You see, I come from a very different background.
Hmm.
My entire career I spent in the civil court.
My lord.
So once there is a pleading in paragraph 15, you must respond to it in your affidavit in opposition. If you don't give a parawise reply, then you ask me to see the documents. Half of the documents I can't even, it can't even go to my head.
My lord.
Because it is not supported by any affidavit.
My lord.
Then?
My lord, this affidavit was filed only to get the
Please
present state.
understand, I have told not once.
My lord.
Since the day I am here, I am telling you that I read the affidavit first.
My lord, my lord.
And then I read the paragraph, then I go to the document.
My lord.
So it must be supported by something. You don't respond to it, so it is non-traverse.
My lord.
So your next part of the story is merely a story.
My lord, that will be benefited for the petitioner, my lord. She may dispose of this matter, my lord.
No,
Directing
it's
the
not a question
petitioner
of
to.
benefiting, but you see, your commissioner gets a letter.
This is not
You-
the competent authority, my lord.
No,
This is-
whoever is page 34, whoever it is, I won't remember that much. I'm not that. I don't, what do you call, my commissioner secretary.
Commissioner secretary,
I
my lord, at
don't,
present.
I don't
is the post,
memorize the entire
this is the
petition
government
and
level,
come.
my lord.
I would go crazy if on one day I memorize
are-
everything.
I have to admit, my lord, something is there, my lord.
So
But
you-
now
you're-
we want to rectify our things, my lord. Lordship may direct the petitioner to approach the
We keep
authority.
this pending and then ask him to do it. You
My
send
lord,
a-
that can be also done.
You send a proposal.
Yes, yes.
The office is saying that we have written him several times. You don't annex any document. You produce letters addressed to your departmental
Yes, we have
officer.
copy mark, my
No,
lord.
copy mark is okay. Every letter I can, every order, when I pass an order, I can write a copy to President, copy to Prime Minister, copy to all the ministers in the Union Cabinet. I can write. But I'll have to show that these orders were communicated to them. Marking is okay.
My lord,
Adding 2 more lines in the letter doesn't cost you much of ink.
my lord.
It will cost you extra 10 paisa cost to add 2 lines. But you don't show the proof of service.
My lord,
So half of your what you are submitting
my lord,
is a merely story for me.
my lord.
Correct.
In the affidavit, my lord, we have written, my lord, it may be mentioned that the respondent
No,
authority
you
has
have
been.
said, but where is the proof? Somebody is deprived of pension and you don't give a proof that it is served. We can't even tell the petitioner that you have misled the court. It's a case of
I
pension.
have sympathy for him, my lord.
It's a question of pension. It's not otherwise. Both sides are represented. Mr. S. Dattal and standing counsel for the PNRD department submits that if the petitioner submits a complete application in a format with necessary documents, he has instructions that the respondent authorities would pursue the matter. First, he has submitted that the petitioner was under the employment of the block development officer Golakganj development block within bracket respondent number 9. Full stop. Accordingly, it is submitted that the application should be submitted before the respondent number 9 for being processed. Next para. Mr. A. Chakravarti, learned government advocate. And for Accountant General, who is there? Mr. V. Sharma, learned standing also for the Accountant General is present. Next para. The pendency of this writ petition shall not be a bar for the petitioner to submit application for pension in the prescribed format. This is a prescribed format?
Yes.
Prescribed format with all the relevant documents before the respondent number 9 for being processed. Next paragraph. The petitioner shall file an affidavit of submitting pension proposal. Also, just before that, you also write, the petitioner shall also provide contact number having WhatsApp facility and oblique or email address by which the department can communicate with him. Next paragraph. List after 4 weeks. Submit a proposal.
Hello, please.
Item 24.
Yes, master roll workers.
Lots.
Yes, what is your instructions? You have filed your affidavit?
I have filed an additional affidavit, Your Lordship.
What is the stand?
No, they have not filed their affidavit, Your Lordship.
Yes.
My lord, we'll file our affidavit sometime maybe require, my lord.
We have filed an additional affidavit and.
I have seen that.
Lost. And in
In fact, I wrongly construed it to be their affidavit.
lots.
Okay. Give me some time, let it come after vacation.
Lordship, your lordship may fix a date, your lordship. Because your lordship, three of the petitioners, your lordship, their services have not been extended, your lordship, by the authorities, your lordship.
Otherwise, others have already get the enhancement.
Date, let the court master fix after some time.
Yes.
Because immediately after vacation, we have hardly any scope for any accommodation. Let him say, hey, Raji, next day to that, after vacation, I thought it's like that. We'll check and give it. After some time. Both sides are represented. The learned standing counsel for the APTCL, place for is granted 2 weeks' time to file affidavit in opposition to the matter. Stop this term. We'll get it after some time.
I'm deeply aware.
Item 25 to item 36.
Week's time to file my affidavit. A week's time to file my affidavit.
The difficulty is
Lordship,
the
just
petitioners in this series, except the second petitioner, the others are similarly placed. Where, my lord, we have been denied our salaries in the promoted post, even though now we have retired in 2021 and 2023. What had happened is, my lord, the entire promotion process was challenged by one writ petitioner. There was an order from this court saying that it will be subject to outcome of the writ petition. During our service period, we were not paid our salaries in the promoted post. Honorable Court clarified that there is no bar on the promotion or there is no bar on the payment of salary. This novella has been going on from 2020 onwards. We retired, our pensions are now fixed at the lower stage on interim orders of this court because we are not getting some pension. Definitive Supreme Court judgment saying that once we have worked in a post on promotion, our salary cannot be disentitled. They have not paid us our arrear salaries. They are not paying for those who are even working as of today. And last opportunity was given the last time that they had sought for time, lordship will find on 26 to 2024
That day, the notice was issued on
that the
26 to.
instructions were not complete. Lordship will have that order
Updated
on
instructions.
4088 of 2023, lordship.
Updated
26 to
instruction, Lordship.
2024. Repeatedly, the same thing is happening. Affidavit is not coming up.
That's why I just pray for a week's time. Lordship.
And on the other case, WPC 4373 of 2020, the petitioners and the state respondents have completed pleadings by filing affidavit and reply. That could be heard and disposed of. That is disposed of everything else.
Yes, 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 it is true. Item number 20.
We are respondents in a private respondents. I will not be required to file my affidavit in opposition. State will take care of it. They have taken care of it. They have filed an affidavit in opposition. Reply has been filed. But because of this tagging, my lord, that case is also not being disposed of. We are deprived of salary and pension.
Item number 26, Lordship, leading to a complaint.
26.
Because of
Pleadings are
that
complete of that.
order in that case, Lordship, outcome of the writ petition, that's why
There was an interim order. And then there were clarifications in aisles. In fact, in item number 26, if lordship permits me, there are two writ petitioners. One of them is the law officer of the department, therefore affidavit is not coming up in my other writ petitions.
Lordship, I have
One
the-
of them is the law officer,
I have the parawise comments.
and therefore the affidavit is not
Just
coming
the
up now.
next time, Lordship, in 2 days, I'll file my affidavit.
If this was the instruction available on the last occasion, why was the affidavit not filed in the last 4 months?
Notice was issued, Lordship, only on the last date, 26
No, no,
2024.
because you see, we do certain things having very good faith on the government
Lordship,
officials.
after notice has been issued, we are served with the extra copy, we sent it to the department and
Let
after
her make a
they
statement that the law officer is not
they
the
give
writ
us the
petitioner
parawise
here.
comments, Lordship. In fact,
See, because that's not fair.
Lordship.
Number one, if the writ petition is pending since 2023, it can't happen that you have not made a prayer for extra copies and you were not given.
Notice was not sure.
No, no. Notice was not sent. That's you see, that's the advantage you are taking of the goodness of the court. We ask you to produce instructions.
Instructions I have placed, Lordship, every time I have placed. I have placed on the last occasion, Lordship, I have placed.
Where is
That
that
was not,
instruction?
that was incomplete.
No,
I
so
placed, Lordship.
now
This was the last instruction.
now he is making that statement that the law officer is the
One of the
technical
petitioners, petitioner number 2. I'm making a straight statement, lordship may record it, take it from the department.
No,
If it is not, if he is not handling the file.
Lordship, they have given me the pair-wise comments. It was on my part, Lordship, I couldn't file because I was.
without copies.
And
We are
only,
getting, no, no.
Lordship, their stand is
Yes.
only because the order in item number 26,
You see,
Lordship.
don't take everything for granted.
No, Lordship.
You mean to say that at your objection, notice of motion was never issued?
No, Lordship.
No. So this court by previous orders asked you to give information.
I have placed, Lordship.
This
Court
is on
was not
28,
satisfied.
2023.
Lordship, court was not satisfied with this instruction, Lordship. So I have brought the updated instruction, Lordship.
It's absolutely unfair. That is why in most of my cases, I always issue a notice of motion. Otherwise, what happens on the day of disposal, these things come up.
So many repetition, Lordship, many repetitions.
there may be hundreds of it. See,
Someone is retired, somebody is still in the
Ms.
service.
Farah, this is not an answer. If I can come prepared with the files coming to me yesterday, you can't have an excuse that there were so many cases I couldn't prepare.
No, Lordship, notice was issued only on the last day.
That's why you are taking advantage of the court's goodness. Court wanted to take instructions from you so that the matters can be disposed of at the motion stage. We do this because of the reason where we find that this matter should be ended up early. We do that exercise so that in the motion stage itself, it can be disposed of because it comes top in the list. Therefore, notice is not issued and it carries on in the motion column. So we do this to get the petitioner benefit of the requirement which the court deems it appropriate that we don't issue a notice. If we go for admission and we issue rule, then it comes for hearing after we don't know how many days. And then you're now, after 1 year, now you are taking a plea that notice of motion was issued only on the last occasion and therefore you did not file an affidavit. That's something which is unpardonable. And when there is a statement that the law officer himself is a petitioner in the first case, that the affidavit is not coming.
No, Lordship,
affidavit
the
has come on
affidavit has
that,
to be
on
from
the
the
others
commissioner
it
and
has not
secretary. The law officer is of the directorate. And the affidavit has to come from the commissioner and secretary.
Then
So
we
he
ask the
has
commissioner
never-
secretary.
yes,
Then we
never-
ask the commissioner secretary to be personally present. We fix it on Monday.
No, Lordship.
We asked personal appearance of the commissioner. Why he did
Lordship,
not,
he has given me the pair-wise comments, Lordship.
no, but he has not filed an affidavit. Parawise comments, this Parawise comments is of
Lordship, my
20
affidavit has gone for vetting, Lordship. I just pray for 2 days time, Lordship.
We give you time till Monday. Do it by Monday
Yes, Lordship.
and don't take this plea. I'll be very annoyed. The reason I told you, you can ask, you can go right now to each and every court and ask why matters are being deferred in the motion stage. If you have the courage, go and ask all the courts, they will tell you the same thing.
But item
That
number,
we are putting up matters in the motion column to expect a early disposal at the motion stage. When a matter is kept pending for a year, that means the court has an anxiety that this matter should be disposed of at the earliest. And therefore, we don't issue a notice of motion. Because otherwise it will come in admission, it will be down in the list. And when the standing counsel of the government advocate accepts that situation, you can't turn around and say that notice of motion was issued only on that day, therefore we had no business to file a response. Something, at least so far as I am concerned, it will be unpardonable.
item number 26, Lordship, pleadings are completed. Item number 26, Lordship.
So we hear that.
Pleadings are
Today, at
completed.
the end of the day, we will hear it. We'll pass orders in item 20, the earlier item. 25, we'll hear it after some time. The other item will hear it. At the end of the day, last, about 4 o'clock, we'll take it up. It will.
Lordship, item number 26, she is the petitioner.
Lordship, we are representing hearing the private respondent number 6 and 7, Lordship. And we are the petitioner in
ఎట్లా కరెక్షన్ నా ఇటు
WPC
ఖాళీ
number
26
4373
reading to complete
of
sir. Reading is complete only in item 36. 26. So only 26 keep it.
Petitioner, she is the petitioner.
Lordship, my senior is out of station for medical reason, Lordship.
26.
Lordship.
But you are holding up the salary and pension. We give you a direction that in the post which the petitioner was you were earlier in what post?
We were inspector in
Inspector.
agriculture. Now we were promoted to statistical officers.
As statistical officer.
Yes, my lord.
So that salary for the inspector, at least that should be paid.
There is
something-
We were paid
There is
inspector
pay,
salaries.
Lordship.
The statistical officer
So you are
salaries.
getting that pay.
Yes,
That
yes,
pay
definitely,
we got
Lordship.
during that time and we retired. While we were posted as statistical officers. Now the.
Okay. So
Because
for the time being, till we hear the matter, his retirement benefits for that post should
Yes.
also be released, which will be subject to
Yes,
further orders of the court for the promotional post.
yes, yes,
Correct?
yes,
That you will process.
yes, yes.
If medical leave, then we can't hold up. But pension for the petitioners who have retired, that will be processed within.
Those are the.
What is the procedure? Sir,
Provisional one has got it.
Provisional they are getting, Lordship, provisional they are getting.
provisional pension
Provisional
also-
one is getting.
In fact,
One is
Lordship,
getting
the
provisional in the post of IO under orders of this
Lordship,
honorable
the
court.
IA, Lordship has.
Yes,
passed
on
the-
one of the petitioners is getting a
Lordship, the
provisional
last
pension
minute of the
in the post of inspector. For others, since there were no orders from this honorable court, other
Lordship.
retired persons have not been
Lordship,
granted.
copy.
And in fact, if Lordship would see,
Just a moment.
yes,
So this Mohan Chandra Gogoi, he is getting,
yes,
others are not getting.
Everybody is getting.
no,
He's saying no.
I have
He's saying no.
those provisional.
নাই পোৱা, অঞ্জনে নাই পোৱা।
Okay,
কালি আহি লগ ধৰি গৈছে, অঞ্জনে নাই
So if not
Yes, yes,
paid, then
yes,
that
yes,
will be
yes.
processed,
পোৱা।
provisional pension. After vacation, give a date.
And the other, my lord, other retirement benefits, at least at that,
You take one by one. Because we have a very short vacation. Correct.
in fact, in the writ petition, there is no allegation against 7 of the writ petitions
No, that's okay. We,
They are not
my
been
money
agreed
take up.
by our promotion. It's just because we were
Once-
they promoted, we were made parties.
No, my difficulty is once I close the file, then I won't remember anything.
No, no,
So let me pass orders which are
Irrelevant.
what you call, I'm those foolish people who drink, who dig a well when he's thirsty. Correct. So for the timing, we give you some support, but nothing more. It is in this, give a common order. You say in item 26 is
Different.
in connection with WPC 4373 of 2020. Comma, Miss
And Shyam.
and Shyam, Lanet Council submits that the council holding the brief is on medical leave. As he has gone out of station for treatment. And therefore pays for adjournment. To stop. Accordingly, this series is deferred. Next para. The respondents in the Agriculture Department shall ensure that affidavit in opposition is filed positively on 15/7/2024. Failing which the court would invoke the doctrine of non-traverse and presume that the respondent authorities have considered to the, have admitted the claim of the petitioners. Full stop. Next paragraph. The learned counsel for the petitioners in which item you say he is the petitioner? Item 26.
I am the petitioner in.
No, no, no. The
Item
law officer,
26.
item 26. So in this connection, the learned counsel for the petitioners in other cases except WPC 4373 of 2020 has submitted that one of the petitioners in the said writ petition is the law officer of the Directorate of what directorate?
Agriculture.
The Director of Agriculture, Assam. An apprehension is expressed that as he is an interested party, perhaps affidavits in other writ petitions are not being filed. First off, we take note of this said submission. However, as the court has already indicated that doctrine of non-traverse will be invoked, it does not matter whether we stop at that. Next paragraph. Reply, if any, by the petitioner be filed within how much time?
I'll take a day or two. A week time.
So within a week thereafter. List on, give a date. 29 July. Oh, no. 29. No, before that you write. So stop. The pendency of the writ petition shall not be a bar for the concerned respondent authorities, including the Director of Agriculture, Government of Assam, to allow provisional pension to all the writ petitioners for the time being treating them to be holding the post of Inspector of Statistics within bracket agriculture, bracket closed. It is made clear that the release of final pension shall be subject to further orders that may be passed in the connected writ petitions. In these writ petitions, wherein the petitioners are claiming entitlement to the post of, to the promotional post of statistical officer.
We were promoted.
That is under challenge.
Yes, yes.
Our posts are not. That is what I'm
Achha.
saying. Even in the repetition, they have not challenged our posts.
No, that notification,
Oh,
promotion
okay.
notification is under challenge.
As the petitioners claim to have been duly promoted
Yes.
to the post of statistical officer agriculture. Next paragraph, list on 29/7/2024.
Bless.
Oh, your presence, everything recorded. Mr. B. Sharma and Mr. B. Chakravarti, studying counsel for Accountant General. Sahar Dhaul,
Number 2, 26.
additional senior government advocate for respondent number 2.
Lordship in 34, respondent 5.
Respondent
5 in 34.
5 in item 34. Oh, you are also for AG. Okay. All the respective counsel for AG. Don't say name. All the respective counsel for AG. Okay. It's okay. Name will not be required. It's okay.
Bless.
This was difficult than a second appeal. This was difficult than a second appeal. Okay. What I do?
Upgraded item 53, election petition 3 of 2021.
Both sides are absent on call. It appears from the record that the names of earlier set of counsel for the petitioners has been deleted from the cause list as they have disengaged themselves in the case. Full stop. As per office note dated. Give a gap. The office note dated so and so. The petitioner is not engaged any counsel so far. Stop. Accordingly, it appears that the petitioner is not interested to pursue this matter. Stop. Accordingly, this matter stands dismissed for non-prosecution. Section of I think that gap date from him after some time. There's no date.
Item 37.
This business lordship, I challenge the VRS letter dated 3/4/2023 lordship, NFR page number 47 lordship. I came to know that my husband got voluntary retirement of his services here lordship. Only after filing WPC number 1788/23 lordship, wherein claim pensionary benefit of my deceased husband lordship, but subsequently lordship authority has let me know that my husband got VLS lordship. So may I please to read this letter lordship? Annexure D page number 47 lordship, that is the VRS letter issued by the respondent authority lordship, stated that lordship. May I please to read it lordship? Information regarding pension benefit of late Constable Hema Kumar.
Yes.
Your letter number, page number 47. Your letter number nil dated 7/2/2023 seeking pension benefit of your husband, late Constable Hema Kumar of this unit. With due respect and reference to the subject cited above, I have the honor to inform you that after scrutiny of the record of this unit, it was found that late Constable Hema Kumar submitted an application on 28/3/2018 for voluntary retirement from his services. And after receiving his application, he was given 3 months time
for rethinking on the matter and then to submit his final decision on or before 30/6/2018. By this office memo number so voluntary so dated Ligiri Pukuri 28 March 2018, letter dated 29/6/2018. He resubmitted another application for the same, and on his request, his prayer for voluntary retirement was accepted on 30/6/2018 by the commandant of this unit. Again stated that lordship that as per his service records, he completed 8 years, 10 months and 2 days of his services at the date of his voluntary retirement. Further, I would like to inform you that as per OM number so dated so of the Finance Commissioner and Secretary to the Government of Assam, the minimum requirement of qualifying service of the purpose of voluntary retirement is 20 years. And as he did not completed qualifying service of 20 years, so he is not liable for any pension benefit. On the other hand, GF bill amount of rupees 16,452 only was drawn and deposit in your bank account by bill number so. Submit for your favor your kind information. Your
Yes.
lordship, this letter itself contradictory lordship. In the first paragraph stated that lordship he did not qualify period of service of 20 years, and other hand lordship 30 years of services lordship. In the second stage, first stage lordship, accordingly his application has been accepted as because my husband has submitted his
No,
application.
your discharge is accepted. Does not mean that you see there, what is wrong? They said for VRS, you don't have the qualifying service, but your application for discharge has been accepted and you are terminated from service.
No, lordship,
It's not voluntary retirement.
lordship, the
you will
person
not-
concerned may file application, but your lordship before the authority lordship, but it may be written and until completion of services lordship. As per rule says lordship 56, fundamental
You
rule that
have seen
subsistence.
the affidavit in opposition.
Yes, lordship.
After that, do you have anything to say? They have annexed the documents, they have annexed the 2 letters which you are referring to. And they have also annexed the order of 36.
For your kind information of this honorable court, I am going to draw attention before your lordship. That is the discharge certificate lordship, 2 number of discharge certificate issued by the medical authority lordship. Annexer C page number 27 as well as Annexer A page number 47. So Annexer C page number 27 kindly be pleased, your lordship. This medical certificate has been, discharge certificate, not medical certificate, has been issued by the Annexer C page number 27. Your lordship got it?
Page
27, lordship. Discharge slip, name Hemok Kaur, is it about 39 years, date of admission 18/5/2017 and date of discharge 8/6/2017. Diagnosis FIO seizure disorder. So your lordship, FIO seizure disorder in medically understood to be a state of sudden uncontrolled burst of electrical activity in the brain, and it causes changes in behavior,
You are
movement.
reading page 28.
26, 27, your lordship. That is the type copy, lordship. And vernacular page is the 29.
You see, one wrong word did not make me read any further. Because in your synopsis, you are writing FIOC.
I have also taken one.
FIOC is the term of a fellow of ophthalmology. So therefore, some eye problem.
FIO seizure disorder.
No, it is EIO. Your statement gives EIO, seizure. You are writing this synopsis FIOC.
Lordship, my file 48, your lordship has seen.
When it comes to medical terms, I have special
Lordship,
interest.
I was also noticing the earlier morning also, your lordship was talking about some medical terms, F something.
No, because if I don't read law, I read medical.
That is why.
Making up for not being able to qualify for medical.
2 number of discharge slip. Another one is 47.
48.
Your lordship.
I don't know this EIO seizure. Where did I read that? EIO seizure?
Page 28, your lordship.
Page 28.
20 no, yes, Lord.
EIO seizure, I'm not getting anywhere.
Next is page number
27, your
40.
lordship. 27, 27, page number 27.
There are 2 number of discharge slip.
I'm not getting anything from EIO seizure.
27 and another one is 47. Annexa is not.
47.
Yes. Annexa 8.
47.
47 doesn't say about, in my copy, 47 is letter by the officer
Yes,
commandant.
it's 48. In my case, it also is 48. Perhaps he's referring to page number 48, your lordship, the discharge slip, your lordship.
48, your lordship. 48.
No, this is F10. That's why I'm not getting it.
Exactly, your lordship. This is F10. This is not EIO. He's maybe mistake of fact on his part. Your lordship.
No, well,
Everything has a different meaning. F10, when they give, it's at a different meaning.
Absolutely.
I did not know the term EIO. That's why I was searching. EIO is not coming up.
according to my concern, lordship, he is my husband, lordship. I know.
No.
Lordship, he is
we are
suffering
not-
mental illness.
How
lordship.
much
He
you know
has
your
got
husband, we are not,
disciplinary power at
okay,
that
how much you
relevant
know
point
your
of
husband is not the subject matter of inquiry. Subject matter of inquiry is that you are ill of what disease? That is F10. If you tell us F10, then we understand something, if not entire.
Also, in fact, in my para 13 of the affidavit, I've mentioned it. He could have perhaps rebutted.
No, that's just something I knew. But I tend to forget because I'm not a medical practitioner. F10 is a condition of alcoholic dependency.
Not only this, lordship, he is suffering illness, lordship, at a relevant point of time, lordship, two number
So
of.
now you are
officers
teaching
given
us,
to me admitted,
now you are
and
teaching us,
discharge slip has been
now you are
issued,
teaching us medical more than the medical books say.
lordship, that is FIO seizure disorder.
You show us FIO, we give you a medical dictionary if you want. If you say F10, it's a alcoholism indicator. You suffer from acute alcoholic dependency.
In lordship, next date, lordship, I will produce the all.
You do whatever you want,
after
but when you
getting
use medical terms,
proper
be sure
information from the
of what
medical
term you are
authority,
using.
But lordship, another aspect is that, lordship, one is the vital error.
No, you complete your part. You see, you do one thing and then complete.
Yes.
Don't rush from here to here. If you
In
want
this
to take
regard,
an
lordship-
adjournment, you take it.
Yes, in this regard, lordship, I will approach medical authority, lordship, whatever may be, lordship, and obtain the document, then submit your lordship, and lordship will
Yes, yes.
satisfy, then your lordship will pass. Apart from this, lordship, another new lordship, your lordship,
I can't pass what you call piecemeal orders. If you satisfy me today, we complete the hearing. Otherwise, if you want to satisfy on the next date, no point opening the file again.
lordship, we will obtain medical,
Yes, please do.
yes.
Mr. Sege, please note that we have a long list and your many friends are sitting behind, eagerly waiting for their turn to come.
Lordship,
Correct.
we will obtain medical.
When it comes to
then we'll
medical,
submit
then
you. Yes,
I can say I have some interest.
yes.
You would have saved 10 minutes time if you had indicated correctly the medical term. F10 would have understood something.
And we
First
communicate to the
FIPO,
medical
first
practitioner.
FIOC, then EIO, then we come to F10. So this is, you must prepare yourself when it comes to medical term. It is, yes, next item.
Deep privilege.
Lordship, extra copies.
Oh, sir. What's your represented? On the prayer made by counsel for the petitioner, rest after answering vacation. Summer vacation, make it summer vacation. Yes, next item, 39. Yes, hemoglobin level.
I'm appealing for all the response. I have received already various comments. Two weeks time may be granted, madam, to file it.
Okay, what do you say about the hemoglobin? Hemoglobin level should be how much?
12 to 14 lordship, general lordship. But here the petitioner, they found 10% lordship. But when the petitioner went to the chief minister free health camp lordship, then they found a 15.2 and 13.9.
No, review medical was when?
Medical.
Where is review medical?
It was review medical board,
Review medical shows 10.1 grams.
10.1 gram lordship.
They will not be entitled.
There's the lordship.
No, you see, we know the easily available drugs. The doctors can prescribe you drug which will increase the hemoglobin level, and then you go and have it tested. Then you will find that your hemoglobin level is high.
They have not given any time of the present petitioners for increasing their hemoglobin. Only 2 point is less they found.
No. 2 point is huge. So in an army, when you have to carry a backpack of 15 kgs, normal backpack and run. You think running a marathon with a 15 kg pack is so easy?
That petitioner just give simple lordship. Their prayer is that for conducting fresh medical board lordship, and then they may appear again.
No, that can't continue. That can't continue. But you file an affidavit. Both sides are represented on the prayer made by Mr. A.K. Ratan at CGC. 2 weeks' time is granted for affidavit in opposition in the matter. This after answering summer vacation.
No,
40.
May appeal also. A matter relating to suspension matter. Suspension order is case 34 matter. Case 34 matter.
Just a moment. What is the date when your show cause notice was issued to you? You're suspended on which date?
Case 34 matter.
30, no, give the date.
Pilot suspended on 25-23.
Yes.
25,
23.
23. The
And
show cause notice?
was 19/7/23. So
Then
within
if they
60
extend your suspension and give you 75% of your,
It's 75% already allowed matter.
he is being given.
then what is wrong?
No, madam,
If the DP has
75%
been-
allowed matter.
Huh?
75%
No,
petition.
it's okay, then what is the wrong committed?
My lord, my ground is, my lord, even after expiry of 3 months, my lord, they did not
No,
extend.
after DP, is it required?
Yes.
They would just merely give a short order extending your period of suspension.
Yes. As per my lord, Ajay Chaudhary case, my lord, as per Ajay Chaudhary.
Ajay does not say that after DP also you have to give a speaking order.
Para 22 is clear, has my lord, para 22 of Ajit Chaudhary says that once my lord, the charge sheet is filed, that 21 goes.
No.
See,
There must be reason order, my lord, even after, my lord.
No,
they
after
issue the
that,
charge sheet, my lord.
after that, the
Yes, sir,
extension
what-
itself is a reasoned order. 2 days back, I have authored a.
Yes. That case of revenue department, my lord.
I don't know, I won't remember.
Hajarika, Ashirwad Hajarika case.
Give us the number. Few days back, I think last week we disposed of a matter on the same ground. The reason order is not required thereafter. Supreme Court has cleared it. It's not the wisdom of this court. What is the name you said?
Ashirwad Hajarika, that the petitioner.
Ashirwad Hazarika. Just check up. Ashirwad Hazarika. Disposed of by this court.
Very recently, some 3-4 days back.
I won't remember that much.
My lord,
I have very
they
weak
were,
memory.
my lord, they were discussing this matter in the corridor. I just.
I have a weak memory.
Not.
You see, you check up this para 22.
Miller.
Ajit Chaudhary, please check up that judgment.
Para 22.
Para 21 and 22.
22.
You read 22.
At 21, I am giving, my lord.
No, read it because this is something I have read.
Yes, my 21, my lord.
22.
22. So far as the facts of the present case are concerned, the appellant has
1 to 4 years.
and now been served with a charge sheet, and therefore
You have to tell Mr. Taylor.
this a direction may not be relevant to him
any longer.
It is
However, if the appellant is so advised, he may challenge his continuation suspension in
Continuous
any manner known to law. And this action of the respondents will be subject to judicial review. And that is the
So
22
known to
matter.
law is something which is not there. That's why Supreme Court says if known to law.
Hmm.
That law is not known even to us.
not by number.
Because every case is being built up on Ajay Chaudhary.
Ah.
Ajay Chaudhary para 22 has clarified.
Clarified.
21 is in a different footing.
Once charge sheet filed, it goes on different.
Then merely a statement that pending departmental inquiry is extended is good enough.
Yes, only my lord, they have issued the notice show cause.
No, 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 my lord, not
Reply
like-
already replied show cause, my lord.
I don't know.
Reply given, my lord,
I don't know.
proceeding is going on, my lord. We have said it in our affidavit.
Yes. Proceedings is going on, pending.
No, let him complete. Let him
Oh,
complete.
I'm sorry, my lord, I'm sorry.
Hmm.
I apologize.
Yes. But there's nothing on record to show that you have issued a yes, issued a show cause notice to them.
Yes, my lord, show cause notice received and replied also, my lord. Replied also submitted, my lord.
We have made it part of annexure of the
Which
affidavit.
one?
Affidavit, my lord, our affidavit. Page number 51, my lord.
No, but this is defective then. If you're referring to page 51,
My lord.
that is defective. You don't give a statement of allegation, you don't give the articles of charges, you don't give the list of documents, list of witnesses, nothing is there. How could you commence a disciplinary proceeding like that? You come to page 53.
My lord.
Para 2, he says, I am preparing my written statement in total darkness about the documents on which the department proceeding is going on. He admits that he was arrested
Yes,
on a trap.
trapping case.
He admitted, but you don't, if that is so, then your departmental proceeding will not stand. If that does not stand, that means your higher ups are happy with him. You only suspend him because he was caught with a very low amount. Mr. Dhawal?
My lord. Show cause we have given, my lord.
No, that's okay, but this is not a proper show cause. I think you are angry because he was caught with how much amount?
1,000.
1,000.
Yes, ma'am.
So therefore you are aggrieved.
Only 1,000, ma'am. Allegation, madam. Allegation is, my lord, only 1,000. If paid, certified copy will be provided. That is the allegation.
This is not how you issue a show cause notice. Let me know the result of your show cause disciplinary proceeding. So, Mr. Dhawal, your officers wanted him to be reinstated.
And she is a physical handicap. 60% disability.
If my lord is taking this suo moto, my lord, otherwise the proceeding he hasn't challenged. That he did not, he is before your lordship only on the ground that it does not review.
Okay, then we go by paragraph 21. You can challenge the proceeding as known by law.
22, my lord.
22.
22.
Okay. Now you have the answer. Heard Mr. M. Islam, and counsel for the A.M. Ahmed, and counsel for the petitioner, and Mr. R. Dhar, and standing counsel for the additional senior government advocate appearing for
Appearing for my lord here. One, three, four, 3 and 4, my lord.
1, 3, and 4, and Mr. J. Hendik, and standing counsel for the revenue department appearing for respondent 2
Only two.
and 2. Who's for 5? JD?
I will appear.
Mr. Dhar is also for 5, huh? By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed his continued suspension by order dated 25/2023. By relying on the principles laid down in the case of Ajay Kumar Chaudhary versus Union of India. What is the citation? Oh, sorry, this is not Union of India. This is
2015.
State of Uttar Pradesh. Ajay Chaudhary is state of
2015 7.
No. Ajay Kumar Chaudhary versus
Ajay Chaudhary versus Union of India and another.
India and another. Citation is?
That is 2015 7 SCC.
Page?
Page 291.
Next one. The learned additional senior government advocate, by referring to the affidavit in opposition filed by respondent number 3, has submitted that the petitioner was suspended by order dated 25/2023. So, however, departmental proceeding was initiated against the petitioner by issuance of show cause notice dated 19/7/2023. So it is submitted that orders were passed for extension of the suspension period from time to time. Full stop. Next, the learned counsel for the petitioner has submitted that the subsequent orders of extension of the suspension was not by a speaking order, which is required to be passed in terms of paragraph 21 of the case of Ajay Kumar Chaudhary. From the materials available on record, it appears that the petitioner, on receipt of the show cause notice, has submitted his reply on 27/7/2023. Full stop. Next paragraph. From this order, you copy para 16, this order. Para 16. Hmm. 17. Next, it would also be appropriate to go to paragraph 21 and 22 of the case of Ajay Kumar Chaudhary. Next paragraph. On a reading of the of paragraph 22 thereof, it appears that as the show cause notice has been issued issued to the petitioner, there is no requirement of passing of a well-reasoned order for his continued suspension, and the extension of the order of suspension would suffice. Next paragraph. Be that as it may, the order in this writ petition shall not preclude the petitioner to assail the department proceeding in a manner which is permissible by law. If so advised. Full stop. The observations as indicated above, this declaration stands closed. Is it very- I'm just asking the members of the bar. In fact, because of my health condition, I have put the AC in a low volume. Should I increase it, or you are comfortable with that? If required, you can ask the fan to be open. Yes, not in a good conditions, therefore I reduce the temperature. Okay. Oh, you are there. Yes.
Not sure.
You record your presence. We are discussing it.
My presence may be recorded.
Okay. Record the presence of Dr. P. Mary, counsel for the respondent is present. Okay.
I'm deeply obliged, Lordship.
41. If you are uncomfortable with the cooling condition, please tell us. Okay. 41.
Grievance of the petitioner pertains to non-consideration of his case for appointment under the ST Hills category. In fact, there is a statutory rules which mandate that every government service should comprise of 5%
Yes.
of the ST
You
Hills.
filed your affidavit.
Lordship, we seek time to file our affidavit.
How much time? You already get 6 months.
Lordship, we've been recently engaged. Kindly allow us 2 weeks' time.
No, you were newly engaged. But the respondents did have notice of this petition.
Lordship, may please allow us only 2 weeks' time. We'll ensure that the reply is filed within this week.
Okay.
Before the vacation.
Ms. D. Borgohain, counsel for the petitioner is present. Ms.
D Gupta, Lordship.
D Gupta, then a counsel appearing for the respondents. Praise for him is granted 2 weeks time to file affidavit in opposition in the matter. So list after the ensuing summer vacation. If it's not listed, make a mention.
Lordship.
Because after vacation, we are in a difficult position.
Lordship. On that issue.
42.
Lord, in this case, I'm appearing for the respondents. I pray for some time to file our affidavit.
Okay, how much time?
The vacation 4 weeks, man.
4 weeks. Okay. Both sides are represented. Wait. The learned counsel for the respondents prays for and granted 4 weeks time to file affidavit in opposition in the matter. List after 4 weeks.
Proceed, state me please.
Make a mention after that.
Loss.
We are in a difficult situation.
Deep levels.
By the time we tide over this vacation, prepare for listing of the matters after the next vacation starts coming in. Please make a mention. Right at this moment, we are in a difficult position. 43.
Item 43.
Last occasion, my lord, I directed the respondent, my lord, to take obtain instruction, my lord. Matter relating to family pension, my lord. High Court's order is page 32, last order, my lord, page 32, my lord. Court directed the authority to disburse the pension money proportionate manner, my lord. But, my lord, as per impending order, my lord, on the basis of some legal opinion from the local government advocate, the the GPF and other pensionary
But
benefits.
Mr. Ahmed, you'll have to tell us one more thing. There are many orders of the Supreme Court as well as this court that repetitive writ petitions, repetitive writs cannot be allowed. Why you did not file a contempt then?
I know, my lord. Petitioner is the first time approached before this honorable court, my lord. Earlier, respondent number 6, my lord. She has approached, my lord. Respondent number 6.
You are not the.
Earlier, I am not before this honorable court, my lord, as a writ petitioner, my lord. I am the respondent. I was the respondent, my lord. At present, my lord, petitioner is the first time, my lord, approached this honorable court. My impending order is case 41, my lord. Though this honorable court directed to disburse the pension, my lord, of a proportionate manner, my lord, but as per impending order, my lord, divided in 50-50, my lord. Without considering the fact that, my lord, petitioner having 2 children, my lord.
Where is the operative part?
Page 32, my lord.
37.
32. Operative part, page 37. 36 para 12, my lord.
Yes, you have the instructions, what is happening?
Lordship, I have the instructions.
What does it say?
Lordship, I would like to file an affidavit, Lordship.
You just let us see what is there. Just tell us what is there in short. Just tell us in short.
Lordship, there was a succession case. Accordingly, they have disbursed that amount. And this pension related things, they have not brought up in the succession case, Lordship. That is that part we have
You, that will have to deal separately because pension is not a, what you call, it's not, it's by law, operation of law, therefore it's not by succession. The judgment of this court.
and the pension part, Lordship.
The pension was held in by this court that is not a property of the deceased, therefore no succession. It is the estate which will devolve on the beneficiary.
Pension part, Lordship, that part is not complete instruction is not here. Lordship. Only it is written that it has been submitted to the higher authority. That part I have to make it clear, Lordship.
Okay. Well, Mr. A.M. Ahmed, Grand Counsel for the petitioner. Mr. C. Sharma, and standing counsel for the.
I'm not standing on, Lordship.
For?
I'm 125, restaurant number 125.
For Water Resources Department.
Yes, Lordship.
Place for some time to obtain instructions and file affidavit in opposition in the matter. So he submits that the instructions are incomplete. Mr. H. Chakravarti, a government advocate, and Mr. K.K. Mehdi, on behalf of Mr. S.K. Mehdi, standing counsel for the Accountant General, is also present. Next matter. Let a notice of motion returnable in 3 weeks be issued. Requisite extra copies of the requisition be served on the Ranat State and Departmental Council in course of the day. Next paragraph. The pendency of this requisition shall not be a bar for the respondent authorities to act in accordance with order dated 3/8/2022 passed by this court in WPC 9392 of 2019.
Yes, Lordship.
44.
May please, Your Lordship. Look, last time your lordship granted time to kill 19 Miller to file affidavit. They have not filed it. Because I am not going to any other fact, because I will go by their instruction itself. So your lordship, either your lordship can take up this matter for final disposal. I am not going beyond their instruction, not a single word.
Yes.
My lord, what happened in this case, the petitioners were rangers of the, in the batch of 89-91, they were appointed. On 18-12.
You remember, you are saying that two conditions are not there.
Beg your pardon?
Two conditions are not complied.
Three
with.
conditions.
Three conditions.
One is suspension, one is departmental proceedings, charge sheet was issued, third, criminal charge sheet submitted. These are the three requirements, my lord, to keep in seal cover. These three, according to their instruction, the clearance from the regular inquiry was not there. Their meaning thereby, my lord, there was no charge sheet in criminal case, there was no charge sheet in departmental proceeding, no suspension. And therefore, my lord, is covered by the judgment of this honorable two judgment based on the Supreme Court judgment. If they want to prepare, my lord, I can grant them time to Wednesday, my lord. If they want,
No, unfortunately, granting time is the prerogative of the court.
no, my lord,
can-
no, my lord, I'm sorry, my lord. I can
Concede.
accommodate them.
You can concede.
Yes, my lord, I can accommodate them to till Wednesday. My lord, I'm not going beyond their instruction, not a single word, my lord. Because their instruction is very clear. That no,
I remember that last day you make a submission.
my lord,
You made that submission, I remember it.
my lord, instruction is very clear. That only that vigilance, regular inquiry, they are so vigilant. And that to regular inquiry, my lord, your lordship will find of 2015, my lord. And 21, in 21, they gave me promotion. That your lordship kindly have a look on page.
They may not have corruption with them.
Beg your pardon?
They may not have corruption with them.
Look, what happens if that is my hardul,
I don't say Sherlock Holmes, I'm using the Indian
Yes.
term.
That's,
Yes, what are your instructions?
My lord, those instructions are very clear, my lord. If, repeatedly we're asking for instructions, my lord, this is only the, this
No,
is,
no, just see.
that regular inquiry is pending, my lord, by the vigilance, and that is the reason seal cover procedure has been adopted.
Just pass it on. I don't have a copy of that.
দুখন লাগিব দুটা আছে instruction না
I don't have a copy of that.
That's two instruction will not. Both are same instruction.
What is your name?
My name is, one is Pranjal Kotoki. And another
Pradeep Bhuya.
Pradeep Bhuya Mila. Mila, vigilance of 2015 below. And 2021, they gave me promotion.
What is it?
Huh? Annex, sir, which one?
Annex, sir?
Page 19. ACF follow promotion delay. Right?
Well, I find a very peculiar issue out here. Madam, if he has been granted promotion in 21, madam, that 14, this inquiry would not come in his way because the theory of wash down theory comes in, madam.
That's what is asked. Target.
Yes, madam. So I'll submit, madam. Lordship will keep this on record. Copy these letters, madam, in the orders, madam, and we can perhaps consider, madam. The next DPC, madam. I had oversighted, I had overlooked this 19, page 19. Wash down theory is very clear. If you are giving him 14 is there, my lord, you give
There's
it.
only one exception to the washout theory.
Yes, madam.
There's only one exception
One
to the washout theory. Okay. Dispose of these cases.
My lord, will kindly, my lord, the order what lordship is passing, my lord, will kindly refer to this books, my lord.
These two.
These two, my lord.
You want this to be made a part of order?
Yes, madam. It will save me my minutes.
In this court, have you ever found that I have
No,
I have put words in the mouth of the standing counsel?
No,
anything?
so that's the reason I was asking, my lord.
When you don't argue anything, you will find in my order vehemently opposed. I use that word. If I use the word vehemently opposed, that means there's no argument at all.
My lords.
Normally that what you use.
Huh?
Normally that word used always.
Okay. Okay, I'll dictate orders in the chambers.
Always. It will be number.
Okay, you have there and dictated, otherwise I have to spend my personal time there. Now, let me dictate the order. Heard, Mr. S. Bernard, counsel for the petitioners. Petitioner. Also heard. You're appearing for all the respondents?
All the respondents.
And Mr.
D. Gogoi, my lords.
Mr. D. Gogoi, Leonard, standing counsel for the Forest Department,
All the respondents.
appearing for all the respondents. Next one.
He's a good jacket. He's a good jacket.
Right? It will be issued away at the department of. Department of.
You are presently in what post?
At present ACF, Milord.
ACF.
Conservator of Forest.
Assistant Conservator of Forest.
Milord.
The petitioner is currently serving as the Assistant Conservator of Forest and posted at,
One is posted at Guwahati, Milord, and
this Pranjal Kakoti.
Kotaki, Milord.
Oh, there are two petitioners here.
Yes, Milord.
Okay, petitioners. Petition number one. So is presently serving at which division?
Assistant Conservator for Milord
Or range, it will be then range.
range, Milord.
Yes.
No, Milord, not range. What are they doing? I'll give it, Milord. Okay.
Page 8, page 8.
Page 8. No?
No, it will be at the end of the notification, it will be there, by which you are placed under
3 and 4, my lord. Serial 3 and 4.
3 and 4, page 19.
19, Milord.
Then Kamrup, petition number one is at Kamrup West Division. And petition number two is presently posted at Assistant Conservator of Forest, attached to the Director, Assam Forest School, Jalbari.
Now at
By
present.
our
petitioner-
notification dated 22/2/2024, issued by the, where is that? Where is this 24 document?
24 document at page 23, Milord.
Twenty.
Oh, recall list.
What is the date? I don't get the date here.
My lord, find it in next page, my lords. At page 24, there is a digital signature to secretary.
22 to 24.
February 22, my lords, 24. Page
February 22, okay. Because I can't read. 22. 22 to 2024. Comma. Then the the government in the Environment and Forest Department granted promotion to 26 personnel to the next higher post of
Deputy Conservator.
Deputy Conservator of Forests. Full stop. However, the name of the petitioners were not reflected in the said notification. Now, how did you know that it is,
We came to learn and accordingly file our representation, my lord,
where is that?
at page 21, my lord.
Okay. The petitioners came to know that their names were not included in the promotional, in the list of, in the promotion list due to non-submission of clearance report by the Vigilance Department. Accordingly, the petitioners had submitted a joint representation on 29/12/2023 to the Principal Chief Conservator of Forest and HOFF from Assam to grant promotion to the petitioners from the post of ACF assistant ACF to the next higher promotional post of DCF. Post of Now, what is this? Annexed,
Major, my lord, Annexure A, my lord.
according by filing this petition under Article 226 of the Constitution of India, the petitioners are seeking the direction upon the respondent authorities to declare that the action of the respondents in resorting to seal cover procedure was illegal and arbitrary, and for issuance of a direction upon the respondent authorities to open the seal cover. And if the petitioners are found fit to give them promotion to the next higher post. Next paragraph. The learned standing counsel for the respondents was vehemently opposed the raise made in the petition and has submitted that as there was vigilance inquiry against the a regular inquiry against the petitioner, where government letter dated 24/12/2014, while he was serving as a ranger from Rani Range, Assam. And what is the name of the second person?
Pradeep, yeah.
And similarly, a regular inquiry was also pending at the against the petitioner number 2, where government letter dated 24/12/2014, while he was serving as ranger on Kulsi, KULSI, range Assam, from the vigilance and clearance was withheld. To stop. In support of his submissions, the the Learned Standing Council for the Forest Department has produced copy of instructions, white letter.
It's 4/4/24, madam.
4/4/24. What is this letter confidential?
And this is the communication of the,
No, it doesn't have a date. I have just found the date. It's not there.
it's not there, madam. No, it's a communication from the Department of,
No, that's okay, but it doesn't have a date.
yes, madam. Doesn't seem to reflect.
And the letter and the file number so and so. This is one, this is two, huh? Copy of the said instructions and the communication regarding vigilance clearance report are extracted herein below. Next paragraph. On examination of the instructions and document produced by the Learned Standing Council for the Forest Department. It appears that only a preliminary inquiry is which was initiated on 24/12/2014 is still continuing for more than 10 years. For nearly 10 years. Full stop. Therefore, till date, the petitioner has not been charge sheeted either in any criminal proceedings initiated against him or no charge memo has been served on the has been submitted on the to the petitioner for initiating a departmental inquiry, departmental disciplinary inquiry.
One was when some Badrinath's case was there. Badrinath. Washed up schedule. Badrinath. Forgot the exact citation, madam.
No, I have it.
Madam.
Once you remind me of Badrinath, I will remember it.
Right.
Okay, I have it. Vashur theory as propounded by the Supreme Court of India in the case of Badrinath. You take it after some time, huh? Would apply. As in the meanwhile, during the pendency of the regular inquiry, the petitioners have been promoted by a common promotion order number FRE full stop 111/2019/79 dated 26/2/2021. Full stop. Therefore, if the authorities had any fresh material against the petitioner for the period after he was holding the post of assistant what is his ACF is assistant
conservator.
conservator of forest. That could have been a material for taking deposit to seal cover procedure. Stop. However, in the present case in hand, what is that Supreme Court judgment?
Supreme Court, my lord, 19 Union of India and others
Janaki
versus
Raman.
KB Janaki Raman.
Janaki Raman's case.
1991.
No, give me the copy.
Yes. Paragraph 16 and 17.
It would be appropriate to quote paragraph 16 and 17 of the case of Union of India versus KB Janaki Raman, JANKIRAMAN. Full stop. Next, therefore, This repetition deserves to be accordingly allowed. The respondent authorities. It is held that the respondent authorities could not have resorted to a seal cover procedure for principal recovery. Petitioners, namely so and so and so and so. And as the manner in which this, as the cause for which the seal cover procedure was adopted in case of the petitioner is contrary to the law laid down by the Supreme Court of India in the case of K.V. Janakiraman within bracket Supra. Next, accordingly, the who will open the seal cover? Secretary.
Secretary. Deputy Secretary is there.
Secretary is also there. The commissioner is also there. Now, who is opening it?
Well, the DPC reveals one secretary.
Secretary.
DPC was conducted by secretary. So she has to open it.
Okay. Okay. The secretary to the Government of Assam, from Environment and Forest Department, within bracket respondent number 2.
Secretary.
And or any other authority who are holding the seal cover of the result of DPC in respect of the petitioners shall open the seal cover and announce the DPC recommendation and take appropriate measures as may be so warranted in the event the petitioners are found to have been recommended for promotion to the next higher post.
Well,
the petition stands allowed to the extent as indicated above.
hold it.
Parties are left to bear their own cost.
Marks it.
47.
Lordship, may kindly pass over the matter for time being. Mr. Mojumdar.
No, now no more time being because we don't have time for the time being.
Transfer matter, Lordship. There is no reason of his retention in the present place of posting, Lordship. Since 2012, he is in the homestead of Assam, Lordship. And before delivery of his child, Lordship, he submitted an application that since his wife is going to deliver child, Lordship, so he needs to be posted in the place of his choice, Lordship, in Silchar or Guwahati. But his representation has been duly considered by a board of officers, Lordship, and it was found that there is no such condition to consider his retention in the present place of posting or in his choice place of posting. So he was transferred to Tripura, Lordship, 140 battalion, and this battalion was his second choice posting, Lordship. Then it's
Wait for 5 minutes time, then we pass on this.
Lordship.
Yeah, ask him some other to come. Wait for some time.
Obliged, Lordship.
Yes.
49.
Item 49.
49, my lord, it's a very peculiar case. This person is absconding in a criminal case. Twice rejected, AB is twice rejected. This person, my lord, is accused in a criminal case. AB has been rejected twice, and my lord, he has been absconding. Even we want him to come. But the moment he comes, my lords, and
While I am attending office, while I am drawing the.
No,
my lord, I have.
You give him.
nobody is absconding. These are the, my lords, and earlier also, my lord, 2 rounds of litigation has happened.
No, that's okay.
I need some return, my lords.
I am not absconding, my lord. Whatever it
No,
is,
you
my
see,
lord, I will.
You ask him to come somewhere and give charge or something, you do it and he will go. But if
No, my lords, these was agitated, my lords, this same issue, my lords, two repetitions, my lords.
Yes.
My lord, faulty due to defective representation has been withdrawn, my lord.
No, my lords, one was by Leonard Senior and one was by another set of counsel, my lord. I apprised the court that there's another pending, so they withdraw that, my lords. It's not technical issue, my lords. Same issue was before this court. Then we had asked him to come before the authority and submit papers for whatever claim he has, my lord. He never appeared, my lord.
My lord, substantially I am getting, my lord, since my lord, 2022, my lord. Then, my lord, I attending as directed by the, my lord, annexer, my lord. 5, my lord.
The page number, right?
Annexer, my lord, 22 page 3, my lord. No, my lord, that I have not, but I have submitting a, my lord, at office attending my lord report. In reference to 4/8/2022 letter, my lord. Annexer 3, page 22, my lord. Office বই আছে, তোমাৰ আগৰ information।
নহয় এতিয়াও কৈছো অফিচত নাই বুলি কৈ আছে।
নাই, বতাই নাযায়, বেলেগ কথা এইটো।
নহয় অফিচত নাই, বিচাৰি গৈছে বুলি কৈ আছে।
নাই। দৰমহা লৈ আছে, গৈ
এতিয়া এতিয়া কিনো লাগে?
সাসপেনশনটো হেৰি কৰিব লাগে।
অফিচ কেনেকে গৈ আছে?
There are many people like me wearing spectacles. I can't see everything.
My lord.
At times from our spectacles, you don't see many things. Things get filtered.
My lord,
Because at night I wear a sunglass.
My lord.
I may not see many things.
My lord.
Will give me some time and I have to revert
My
back
lord,
with some
let them, my
detailed
lord,
instruction.
at least instruction, my lord, whatever my lord, subject before lordship, my lord, that is not correct, my lord. As per my instruction.
No, but what is saying makes sense. Because if your bail has been rejected twice,
My lord.
and twice your repetitions are there, which you
But
withdraw.
that repetition part is different, my lord. Prior to my lord engaging me, different repetition pending, then when I come to know, my lord, my was subsequent and I instructed to him to allow me to withdraw. Thereafter, that also defective, that's why I has been withdrawn, my lord.
No. No, that is incorrect. That is incorrect. You withdrew it because of the pendency of WPC 690.
My lord.
And then 690 was withdrawn.
My lord. Then thereafter, my lord, which is a priority in time, my lord, that has been withdrawn because, my lord, some facts
No,
have been not.
because you see, the second case was withdrawn without any liberty. Your present repetition is deserves to be dismissed. You look at these two orders.
Does that?
First was withdrawn because of 690. 690 was withdrawn later on. And therefore, this petition is filed. The 690 withdrawal was not with liberty.
My lord, the lordship is right, but matter has been not, my lord,
Once it is there, same cause of action, second repetition would not lie. It would be dismissed in the beginning. We can't help it.
My lord, because it's a repetition, my lord, because maybe my.
You have to show us the law where when she
Until
referred
unless,
without
my lord,
liberty.
my lord.
Without liberty, it was withdrawn.
My lord, even then also, my lord, any subsequent action if arises, repetition can be filed, my lord.
Not for the same cause of action.
My cause
It
of
is
action, my lord,
suspension.
maybe different, my lord. I'll show it, my lord, because earlier repetition
Then we'll
is.
call for that, but it
My
goes
my
after
lord.
application.
My lord.
And in the meanwhile, you ask him to when do you want the petitioner to be there in your office?
Any date, my lord. See if it's convenient to him, my lord. Let him come in the office hours.
You tell when.
To my instruction, my lord, he's attending, my lord.
No, that's okay, but give a time when you will be there.
My lord.
At 10 o'clock on 26th?
My lords.
At 10 o'clock on 26th, you will be in the office. Okay. Uh, just give me those two documents again.
My lord.
Both sides are represented. Mr. R.R. Goel and
That's D.
sorry, D. Goel and Standing Counsel for the Forest Department has produced
I'll try.
a copy of order dated 10/11/2023 passed in WPC 6475 of 2023 by which the petitioner was given liberty to withdraw the writ petition as in that respect of as in respect of same cause of action. Another writ petition being WPC 690 of 2023 has been filed before this court in which notice was issued. Full stop. Next para. The Learned Standing Council has also produced a copy of order dated 20/12/2023 passed by this court in WPC 690 of 2023 by which the writ petition was dismissed as not pressed. Full stop. Accordingly, it is submitted that for the same cause of action, the present writ petition could not be maintainable as the earlier writ petition was withdrawn without any liberty to file afresh. Next matter. Let the matter be listed after the ensuing summer vacation along with the records of WPC 690 of 2023 disposed of by order dated 20/12/2023. Next panel. As there is a dispute in the bar with regard to the attendance of the petitioner in office. You said while the Learned Counsel for the petitioner has submitted that the petitioner is regularly attending office, the Learned Standing Counsel for the Forest Department has submitted that as per instructions received by him, the petitioner is not attending the office. Full stop. Accordingly, the court is inclined to direct that the petitioner shall. You're in which office?
The office of the
Range Forest Officer, Central Checking Range, Guwahati.
Shall appear before the.
Annexure 4, page 24, my lord. Since then, I am appearing that.
Appear
attending
before
the
the.
office, my lord.
Appear before the office of the Range Forest Officer, Circle.
Central Checking Range.
Central. In your constantly you are writing circle.
Yes, my lord. It's central, man, it's been written page 5. Circular.
No, I don't know, whatever you say.
Central.
It's Central.
Central.
Okay, Central Checking Range. Office of the Chief Conservator of Forest within bracket T.
Central.
No, central.
Circle.
At 10 a.m. and report his presence before the Range Forest Officer of the said authority on appearance of the petitioner shall record his presence and a certificate of his attendance be provided to the Learned Standing Counsel for being produced before the court on the next date of listing. Along with his comments as to whether the petitioner has been attending his office or not.
My lord, other instruction also, my lord, maybe my.
This is
may
whatever
enter is
instruction
not
I-
Defining, my lord.
Pardon?
Other instruction, my lord.
No, because we are now calling for the record. If the cause of action is same, we may be dismissing it. Further instructions, we are not asking for it right now. We are calling for that earlier repetition.
Hold on.
Items 70,
Please,
Yes.
Meetings are complete with the short issue.
that time is also too short.
That is what I was.
Okay.
It may take longer
has to
than
go.
what we have available today.
I don't think
No, I
with-
don't think it'll take longer than what we have today, my lord.
with you and him both.
I
don't
can't say
expect
my
any
lord it
short.
will be over today, my lord.
You choose a date since you are
Whatever
coming from
is
station.
convenient to my lord, and,
Yeah, agree to a date, both of
no,
you.
because I think next week of the afternoon, he is not available next week, so.
No,
after
next
the-
week also we can take up.
After the vacation,
After
whatever.
vacation. You choose a date, both of you. agree to-
31st July, 31st July.
31st July. Make it 30.
30 July. Vale.
What is the issue?
And the issue is whether the petitioner is entitled to pension.
Okay.
Based
They rejected it because they found you not
Not
having
the
eligibility.
rules. The division bench has recorded that he had division bench because he was dismissed from service that was put to challenge. The division bench said that the punishment is disproportionate. At the presence of both the council, the division bench proceeds as if he was in service for 23 years. And the division bench, the whole intention of the division bench, that he should get something that his pensionary rights are protected. So pursuant to that, they imposed fresh punishment where they give gratuity and the provident fund, but the pension is refused on the ground that he doesn't fulfill the minimum requirement of 20 years of pensionary service.
That period of suspension of treatment is maximum? No.
Here, yeah, that is the whole issue. He had been seeking voluntary retirement. On facts, my lords, I don't, my lords, strictly speaking, 20 years is
No,
not
but
fulfilled.
no, not that. But if the division bench has given a verdict,
Division bench has taken date of joining and date of dismissal.
no, that's okay. But once there's a division bench order,
My lord, that is.
can
the
I
whole-
give a contrary finding and say that this, because if the
That they
division
should
bench
have
doesn't say
pointed out
about
to the
tax
division
law.
bench, and when the division bench, the intention was that the punishment should be such that his
No, that is
right.
okay, but I think review before that division bench would have been a proper, because here to interpret that order and say that this,
That is true, man, but,
think over in the meanwhile.
because nobody went, that order has attained finality. And there's
No,
a
but
fresh
still
order.
on that-
That your lordship is right
Yes.
ultimately. And a little interpretation of the rules. There is some opening in the rules where even 10 years, some pension, some proportionate pension may be given.
Okay. Mr. P.K. Goswami, Senior Counsel, assisted by S. Sharma, Counsel for the petitioner, as well as Mr. A. Saiwala Lanet, Counsel for the respondents. Next matter. Due to paucity of time, matter could not be taken up today. Next matter is agreed to by both sides. List on 307/2024. Convening to you?
Deeply obliged.
71.
Oh.
Wait, please.
Sure. Yes, Mr. Mohammed. Yes.
My lord, as per the last order, my lord, your lordship directed us to take steps upon the private respondent.
Yes.
We have taken steps. My lord, in the meantime, the social welfare department has filed the affidavit in opposition. Lord, I need a week's time to file a short reply.
Okay. But is service complete?
Yes, ma'am. Service is complete.
Okay. No, service is not complete.
My lord, regarding the postal track report, my lord, today I went there. They said that they have already sent the file, but they have said that they have already sent the file. They have already sent the file to the court. My lord, in the next day I will produce the postal report, my lord. Deeply obliged.
72.
Well, thank you, Lord. My lord, more than 1 year has passed since notice was issued. No affidavit has been filed by the department.
May I please your lordship? Lordship, I am appearing for Health Department, lordship, on behalf of Mr. D.P. Bora. Lordship, we need some time to receive instruction, lordship. We have not received instruction. You first on behalf of D.P. Bora. D.P. Bora, lordship.
A serious allegation has been made in this writ petition that the respondent numbers 6 to 10 were appointed to the post of ICU technician, although they were not even eligible to participate in view of lack of requisite qualification. Full stop. What about notice to respondents? Is it served?
Yes, they have appeared, my lord.
Who is for them?
In the cause list,
Okay.
name is reflected.
The
as-
private respondents have also not appeared. Are not present when the matter is called. Full stop. In view of the fact that the allegations of the private respondent numbers 6 to 10 do not have qualification, has not been denied, the appointment of respondent number 6 to 10 to the post of ICU technician, wide order dated
My lord, the impugned select list is unaccepted, my lord.
page, give me the page.
Yes. Page number 54.
54.
Yes, ma'am. And my lord,
Page 50.
60 also, 60. Lordship will refer to 60.
Right. Order number HSE oblique appointment APPTT oblique ICU technician oblique 100 oblique 2023-3 dated 25/5/2023 shall be stayed with prospective effect from the date when the certified copy of this order is served on the Director of Health Services within bracket FW bracket close Assam.
Deep level.
Oh, list after 4 weeks.
Deep level.
Item 50 for orders.
Yes, contempt matter.
Please, your lordship. The last occasion, lordship, I was
You,
directed to file
you
an
did not file an application.
application. Still, what happened, lordship? I have lost the phone number. The petitioner is from Kolkata. So somehow I can able to communicate today morning. So so one advocate of Kolkata who has initially sent a legal notice to the department. So I talked over phone with a lawyer, particular lawyer. He asked me to get the telephone number by today. I'll get it the phone number by today evening.
Okay.
The petitioner. So
On
another.
the prayer
I
made
need
by
to-
Mr. T. Vaidya and counsel for the petitioner, the matter stands adjourned today to enable him to obtain instructions. This
4 weeks,
after
lordship. 4
ensuing
weeks,
vacation.
4
This after ensuing vacation.
Pardon, lordship.
We are listing it after ensuing vacation.
High level.
Yes.
Time being 47.
We have filed an affidavit and reply this. Which will like to have it on Monday.
but you are-
There was
But,
an,
since you have been here for long,
my lord,
you have to go.
well, that is what I have written on my affidavit in reply. What they say for that period that they have said, they have only taken the period where I was promoted. My entire service career has not been got on record.
No, but still you see,
I have not been here for long, my lord. I have been in the state for long. And at their transfer orders, I have been here. In the state, if lordship will allow me. Yeah. Well, since my reply is not on record, may I supply one by, just to show, my lord, the assumption that they have tried to
you
bring.
file a reply, but your replies, we don't get it here. We have. Let
I've
it
just
come.
given a copy, it is there. One copy just I have given. Even in the affidavit in opposition, if lordship has that, they have given the chart. Yes, madam. Or lordship will have the affidavit in opposition, I'll show that this is not as they projected. Their affidavit in opposition, page 38, para 9. How words are juggled, madam.
Yes.
Para 9. That with regard to the statement made in paragraph 5 and 6, the deponents begs to state that out of total 14 years of the petitioner's service in ministerial cadre, he has served more than 12 years in the home state of Assam. Now, the petitioner has a total service of 22 years. They try to show it as out of 14 years, I have been here for 12 years. No matter. 22 years. They keep me here in
No, but home.
Assam. Now, lordship will find
No,
on the
whatever
next
be the
page, page
reason,
39,
they have
lordship
kept
will
you here.
My lord.
Whatever be the reason, they have kept you here for some reason.
No, man. Lordship will kindly see page 39.
Yes.
The chart. 87 battalion, it is on detachment. I am at Chhattisgarh. Then, my lord, 2005 to 2009, New Delhi, they do not say why. 2009, Tripura, they are trying to show a period of 9 months. Now, lordship will see all the rest. Normal tenure, any other reason. Normal tenure, there is nothing on record. It is in 2020. They say compassionate ground. Even the order that lordship, if lordship asks for it, I was here. I was transferred to Delhi. I took an interview with the DIG. That could it be somewhere in Assam? The official order came that yes, it is in Assam. There was no compassion prayed for. It was an oral interview. I could have gone at that period of time. At this period of time, then they said that in their affidavit in opposition, they have given a choice that I have given. Lordship will kindly have the choice. They have given a printout sort of a thing in their affidavit in opposition, which lordship should
Ultimately,
find
you
at
are a
page
person of
58.
uniform force. You have to go.
My lord.
You are a member of the.
I have not refused. Therefore, the affidavit in reply was what I was trying to. My lord, I made a statement that I am ready to go. I am ready to go. Serve anywhere in India. My first application came in the month of December 2023, saying that my wife is in this condition, my father is in this condition. Consider my retention for just a year.
So it is considered by
February.
the board. Lordship.
I filed it. It was not, that was not considered. What they did was they have an app
The same.
where mandatorily,
Just let him complete.
Lordship.
then they have an app which they call the Santosh app, where every person who has completed 3 years has to mandatorily fill in their choice. This app does not allow filling in the same state. In the same state, it doesn't allow filling in. So whatever has to be filled in has to be filled in on the choices given by them. My second choice given was Tripura because that was the nearest place, with the expectation that that application is under consideration. Seeing Tripura, the computer has put me to Tripura, not there. Then I make an application. That is considered by the human board saying that you were here for 12 out of 14 years. Issue is I was here 12 out of 22 years. The way it has been placed before this
Oh,
court.
that's okay, but since still it is your home state.
Yes, it is my home state. And there is nothing on their OM. Let her show the home state there is a restriction for 10 years or 12 years or 13 years. People here, lordship, if records are asked for, people are here for the last 26 years.
No, but it's a home state. You may be transferred
In the
outside.
home state, madam. 26 years in the home state I'm seeing. People have served here in the home state for the 26 years. Madam.
No, that's okay.
So what I was just trying to place before lordship is my wife's difficulty, my father's difficulty be taken into consideration in the human way, not by an app, not by the Santosh app.
And this is considered by the board lordship, by the human lordship, and
Lordship,
all-
see the
all-
way it has been rejected.
and there is
Computer did it.
Just a moment. Both of you can't speak together.
Sorry, ma'am. And therefore, my affidavit in reply, I have brought it, and they have spoken of a hospital. They admit that my wife needs care. The hospital name, they have said that in Agartala we have hospital. My lord, it is 80 kilometers away from where their location is.
There is no medical issue of his wife lordship. Only at that time he has submitted a representation that she is in the advanced stage of her pregnancy lordship. Therefore, she needs to be he needs to be stayed in the present place of posting. And already his wife has delivered a child lordship, and now they have come with her medical certificate that she has the probable DVT. Probable lordship. There is no medical, this condition is not in our lordship standing order. On medical
Which
ground,
page you are referring to?
lordship,
Which page you are referring to?
lordship page 18.
18.
18 is the lordship certificate on the basis of which he is lordship requesting for retention in the present place of posting. 3 medical certificate has been annexed lordship. This is before the delivery of the child. This is one.
This page 18,
18
yes.
lordship.
So,
And second is lordship, on the same date, the lordship Composite Hospital has issued a certificate on the same ground, lordship, on the same date. But she was lordship under treatment in the private hospital. So there was no reason of Composite Hospital issuing any certificate lordship on the same ground. Before delivery of
I don't get it.
before
You are
delivery of
referring to
the
page
child.
18,
Now lordship, this is page 22.
page 22.
Page 22. This is the only condition, probable DVT. There is no other reason of his retention in this present place of posting lordship. And DVT is not a ground to retain the person in
What is DVT? I don't know.
deep vein thrombosis.
DVT is deep vein thrombosis.
Thrombosis. Swelling in the leg, most probably lordship.
Let this document be brought on record.
And page 53 lordship. This is the standing order, clause 7 lordship. The medical grounds on which lordship a person can be considered for retention in a particular place of posting. Page 53. There are 7 medical conditions like infertility, cancer, paralytic stroke, renal failure, coronary artery, Parkinson disease, and motor neuron disease. This is only, his wife is not suffering from any of these diseases. And also lordship, this certificate is only
Transfer order.
probable lordship.
Where is the transfer order?
Transfer order is as
So there is a
page 12 lordship of the repetition.
This 140 battalion.
140
Where is
battalion,
transferred?
Tripura lordship.
No, I am not asking for the location. I'm asking you whether it has family accommodation.
Yes, lordship. And also his representation is at page 13. The page 13 is his representation lordship, on what ground he is seeking lordship retention in the present place of posting or choice posting lordship. There is nothing lordship.
But Mr. Mazumdar, once you say that your choice is Tripura,
Yes,
and they're sending you to Tripura, what is the difference?
that is what I'm saying. In the month of November 2023, all persons who sought retention as special consideration, that is their own office memorandum, have to give an application to the through the app, so that it can be considered by the board to exempt him from the routine summer chain transfer. This is done in the month of November 2023. In February 2024, it is compulsory for every person who is serving in the force to fill in their choices in an app called the Santos app. No one is spared. Everybody has to give their choice. Whether I have made an application under special consideration, whether I have completed my tenure or not, I have to give my choice. That application is made in a manner where my transfer is regulated by not allowing me to go to certain places to make certain choices. I made a statement on affidavit. So the nearest place which that app was offering me was Tripura. Since it is mandatory, failing which I will be under a disciplinary proceeding, I have to fill it up. My second choice comes in as a Tripura. I fill it up. Then, Lordship, this order of 2/3/2004 is released. Lordship will find it page 12.
Yes.
And Lordship will also find their statement in the affidavit in opposition where they say that the Santos app makes the transfer order. It is not done by anybody considering the applications or anything.
No, it is considered by the Lordship.
Lordship will kindly see. I will just read out that paragraph where they say that it was totally done by the app. Yes. Page 40. The transfer of the petitioner was issued through software Santos. After considering his hardship score accumulated as per his previous posting. This entire job is done by the Santos app. When one applies under when one feeds in everything, Santos app takes into account his last postings, his age, his qualifications, and the Santos app gives a place of posting. There are cases where people with the last choice have been posted to a particular place where the first place have gone vacant under the entire transfer order, because per the app, it could not fulfill that particular criteria. Now, when a person has made a special application in November 2023, before the operation of that app, before application to that application, in my humble submission, was never considered, which required the first consideration. The second Tripura choice is one under mandate, where they have given me the limited choices. If any instruction can be brought to this before this honorable court saying that no, I had the choice to give somewhere else also, it would have been
That may
different.
be there because if there's a transfer policy,
yes,
which mandates a very circular where you will be transferred,
yes,
then it can be excluded.
Therefore, my lord, even that circular taking into the
Because you see, even if you go to our website, you want to fill up the choice, unless you fill up the parameters, it won't give you.
it doesn't give us.
Correct.
anything.
So therefore, certain decisions are done internally by the online processing.
Yes.
And thereafter, because there's a front office, there's a back office.
And therefore, my lord, they also have a choice. They also have a system where I make an application after the computer makes a choice. But here, the prior choice the prior application that I had given, had it been considered,
Lordship,
this Santos app would not have come.
Then I'll adjourn it.
the
I have-
application is
no,
same,
Mrs. Devi, thrice I have stopped you. When somebody is arguing, please respect the other side.
Sorry.
Let this matter be listed after ensuing summer vacation.
Lordship, only next.
No, you see, I'm also a human being.
Lordship,
I lose patience.
Lordship, Tuesday, Lordship.
It will be extended. I have warned you thrice, not once. I lose patience. It's not that I'm not hot-headed.
Lordship.
It's my way to smile always and then go home happily. I change my, this is only a, what you call, mask I'm wearing. It's only a mask I'm wearing.
Next week, Lordship.
I'm too hot-headed. Both sides are represented. Let the affidavit in reply of the petition in the bottom record, list immediately after the ensuing vacation. Liberty is granted to the parties to make a mention if the matter is not listed after vacation.
There was an
Interim
interim.
order passed and is extended till the next date of the statement.
Obliged.
Obliged.
Item 51.
My lord, yeah, please, your lordship. My lord, I have been instructed by the petitioner that they want to withdraw this contempt petition.
Order has been complied with.
No, my lord, I'm okay. My lord, I have been instructed that their prayer has been, my lord, alternatively, my lord, they are going to comply with them.
Okay. Mr. K. Sinha, the counsel for the petitioner,
Continuing to serve.
submits that he has instructions not to press the matter. To stop. Mr.
AI Ali.
A.I. Ali, counsel for the respondent is present. Stop. Matter stands dismissed, having not been pressed.
Obliged.
52.
There is no representation from the petitioner. It is noted that the petitioner had remained unrepresented, and the matter was previously listed on 12/6/2023 and 7/10/2023. Accordingly, it appears that the petitioner is not interested to proceed the matter. No, I don't pass that order. Yes, due to, don't say, petitioner is unrepresented, however, as the quotas are already over. The matter is adjourned today, list after ensuing vacation. After quotas, I don't want to dismiss.
54.
Yes.
Your matter will be taken up.
Proceedings have been exchanged in this case. I'm appearing for response number 5, 6, and 7. So this can be taken up for final adjudication.
Final disposal.
What is the subject matter of this?
Regarding a pension, my lord, I am the first one. By way
Between
respondent
first
is
wife and second wife.
dispute between first and second. My husband died, lordship. He was a bank employee in the State Bank of India.
Pension has to be shared. Any difficulty in that?
That issue is to be adjudicated, Lordship. I filed my affidavit in opposition.
So what is there to be adjudicated?
Because of the fact we are in the our affidavit, we have stated that after the divorce, because divorce in the meantime has been granted. So these things are there, Lordship. Certain factual aspects are there. So this,
Divorce has been granted.
yes, so some certain facts are there. So I want to place those facts. It will be better to take up the matter for final adjudication. Any date after, immediately after vacation.
Where is the document? I don't see anything. Your
Affidavit in opposition has been filed, Lordship.
please show us that. I have missed it. That is your
Statement,
stand.
my lord, filed on respondent number 1 to 4, my lord, in this particular.
Where is the document of the?
The document is not there, Lordship. We have
Then-
not been able to place those documents, but certain facts are there. We have able to collect certain facts. The petitioner has herself has claimed that she there is some this separation is there with regard to the husband. So this petitioner, she was not staying with the husband, with the deceased person for a substantial period of time.
No, that
So
is
there-
okay.
Yes.
That
So
is
after
okay.
that, because of that, there's a second marriage with the present respondent number 5.
No, that doesn't mean a divorce.
Why I'm
You,
saying so, Lordship,
you,
there's a-
one may not like a spouse and don't stay with her.
I'm not on that, Lordship. I'm saying so because very recently we have come to know about the fact that certain petition was filed before the civil court with regard to certain dispute between the parties. In that particular matter, the petitioner herself as plaintiff made a mention that there was some sort of separation between them with the husband. the deceased
Separation and divorce are two different things.
husband. That this aspect of the matter is to be taken into account because I will place those matters, these facts before this honorable court. So this will establish.
but
the
here there's
interest of
nothing.
The matter.
Here there's nothing.
No, at the time of filing of this affidavit in opposition, these facts are not known.
No,
to the
that is why, you see, we'll miss something when it's not a part of record. When you're making submissions, I can't correlate that with the record.
No, I will place all these things, Lordship. That is why I'm saying that this can be placed for final adjudication. In the meantime, if I
List
can.
after
collect all the
answering the
material,
question.
I'll place it.
All sides are first, all sides are represented. List after answering summary vacation.
Yes. Lordship, fix it.
My
In the
lord,
meantime, I'll
my-
place all these matters. In the meantime, I will collect all the information. I'll place it before the court.
But my appearance, my lord, kindly record 1 to 4 I am.
I have said all sides present.
Okay, it is.
All sides present.
Any date has been given like,
No.
after vacation.
After vacation, we can't give a slot right now.
My lord.
Very difficult.
Yes, yes.
Item 55.
I love this.
Lordship, this is a prayer for fixation of final pension. I have superannuated in 2019 and since then I
No,
have
just
been.
what are the service of notice?
Lordship's service stands complete on 20th February 23 on respondent number 5. There's an order to that effect, 20th
Okay.
February.
Learned counsel for the petitioner has referred to the order of the Lavazima Court dated 20 February 2023, indicating that notice is served on respondent number 5. Who's for 5? No one.
Also, otherwise. No one has come, but I believe because initially, generally speaking, principal is not represented by the government, but here in this case, your lordship,
For the respondent number 5.
lordship, in this case,
Yes.
possibly in this case, your lordship, we can represent because this is a government institute, your lordship. So I will represent as a government advocate. I'll represent for 1, 2, 3 and 1, 2, 3 and 5, your lordship. All those steps were taken separately, your lordship, not.
Oh, okay. No, don't say that. Mr. C. Hazarika, and government advocate appears for appearing for the respondent numbers 1, 2, 3 and 5. And Ms. Unsul and counsel for respondent number 6 are present.
4. Six would be finance.
Yes, have you got instructions about the pension?
Lordship, let me, provisional pension they're already getting, but there's some discrepancy regarding some cash books or something, your lordship. That's why I've got the instruction. Let me file the affidavit, your lordship. Let me fix after summer vacation. And I'll file the affidavit, your lordship.
Okay. On the prayer made by the government advocate, 2 weeks time is granted to file affidavit in opposition in the matter. List after answering summer vacation.
Obliged.
56 with 57.
Perhaps these matters can be taken up after the vacation because these matters
After
can be
vacation
taken up.
goes.
They filed their affidavit.
Possibly time measure could not be taken up today. Both sides are represented. List after answering some of the.
Obliged.
58.
May I please your lordship? My lord, this order has been complied, madam.
What has been complied with?
Yes, madam.
Mr. Goswami, this is your matter.
9.
Now 59 we are taking up. Huh? Oh, acha. Oh, I'm sorry. 58, okay. Mr.
The PH Kumar, madam. PH Kumar.
PH
Yes, ma'am.
Kumar, then counsel for the petitioner, upon instructions has submitted that the order of this court has been complied with, and his instructions not to press the matter. So accordingly, this contemplation and closed on satisfaction.
Item 59.
Payment has filed an application for modification of the order.
Yes.
I think Lordship may take this matter for final disposal.
because I think there is no possibility of, at this stage, it is an order of 2017. Interim order has been passed on the basis of license was fact. We have proved that fact and DTO was not examined. That is why Lordship, the liability was imposed on us. So Lordship has passed a final stay order, complete stay order. They file a modification order.
Yes.
So Lordship may fix this matter for final disposal. It will better, Lordship.
No, this will hardly takes any time. Because this is pending for last so many.
It is order of 2017. Interim order.
May I please, your lordship?
You see, the Oriental Insurance is the company who is
by the government,
who will be making the compensation. They say that the application for examining the DTO was not considered. How can we penalize them for that? Asking them to deposit money. What has happened to the appeal?
Appeal is pending.
Appeal is
and-
pending.
And in the meantime, the respondent claimants have also filed cross objection.
Why you did not press for a hearing of this main appeal? It would have been disposed of by now.
Lordship.
Your lordship, as my learned friend have also said, so if my stay vacating application is disposed of by observing that, then also.
Immediately after.
No, this way disposed of. And we say that the appeal be taken up for hearing.
Immediately after vacations.
Because once the DTO is not examined, you are claiming that he is having a fake license driver.
Lordship, we have called the DTO. DTO has not come. We have issued summon also. He has not come. Ultimately, tribunal has not allowed to call the DTO and close the matter. We have examined the investigator.
No,
as well as-
what is the reason?
No.
Fake license.
Fake license.
Your lordship.
Not fake license. License was not renewed. License was not renewed. At the time of accident, it was not valid.
But then there is a Supreme Court judgment operating against you. It says that when the person has a license but not renewed, that will not
Then-
absolve you of the liability.
They cannot be.
What is the judgment?
Your lordship, Sharan Singh is there recently after Sharan Singh on full bench judgment.
Sharan
is there.
Singh.
Sharan Singh
Sharan
judgment is
Singh.
there.
Following Sharan Singh, 1 3 judges bench of Supreme Court in Francisca Luis Rusa versus K. Balarmat.
No, then we
Has
take it
also-
up for disposal.
Ideal disposal also.
Okay. Both sides are represented. This interlocutory application is for vacating of order dated 26/4/2017, passed in IA Civil 768 of 2017, in connection with MSC Appeal number 95 of 2017, by which the appeal filed by the opposite party, i.e. the Oriental Insurance Company Limited, was admitted without insistence of making any pre-deposit.
Your lordship, stay was granted. Stay was separately granted, separate IA was.
That's what I am saying. That's what I am saying.
It was.
The issue involved on a query of the court, Mr. S.K. Goswami Ranet, counsel for the opposite party, has submitted that in the claim petition filed before the jurisdictional claim petition being MSC case number 1218 of 2013, which was being prosecuted before the jurisdictional Motor Accident Claims Tribunal had issued summons to call for the DTO to be examined as the opposite party claimed that although the driver of the offending vehicle had a license, but it was not renewed, despite orders of the court and summons issued, the DTO concerned did not appear. However, instead of enforcing the order of the of appearance as witness, the learned member, MSCT number 2, Kamrup Metro Guwahati, by its order, close the evidence of the opposite party and proceeded to decide the matter. In light of the nature of grievance raised in the connected appeal, the court is not inclined to modify the interim order dated 26/4/2017 passed by this court in IA Civil 768 of 2017. First, next, the observations made in this order shall not prejudice the parties when the connected appeal is heard on merit. Next paragraph. Yeah, no, next, not next paragraph. Okay. Now you say in this appeal 95. When Mr. S.K. Goswami done counsel for the appellant, and Mr. D. Mandal, learned counsel for the respondent numbers 1 to 7. Yes, what about service of respondent number 8 and 9? We have to take first steps on
We
8
can
and 9.
also take dusty service also. Dusty service will be better, last it now. If necessary, dusty service also.
Who are 8 and 9?
8 and 9 owner and driver.
Okay. As this service report on respondent numbers 8 and 9 is not yet complete, the petitioner shall take first steps for service of notice on respondent numbers 8 and 9 by registered post to the AD as well as by dusty service.
Nothing may record court process and dusty service also.
Both?
Because registered post already taken, it was written unstarted, report has not come. So we have taken, we'll take a dusty service as well as court process. Court process is usually started. Because last it now also.
Okay, just don't say registered. You don't have to take by registered post.
No, court process is better, Lordship, because that's it is managed by someone, Lordship. That is why Lordship did not come.
Okay, instead of registered post, to say usual process as well as by dusty. It is made clear that as who's the owner?
One, Lordship, 6.
No. 8 will be the owner.
8 is the owner.
9 is the driver.
9 is the driver. 1
No.
to 7 is the claimants.
Hmm?
1 to 7 are the claimants, Mondol appeared. And
No,
six-
nine you can't serve by Dasti. They are at Borpeta.
Borpeta. We can engage investigator also. We can send by dust.
You can send. The proposition for Dasti. First of all, the notice is made return, the petitioner still takes, no, the notice is made returnable on, give a date after 5 weeks. Return on so and so. First of all, upon justice service to be routed by the court through the office, through the registry, the applicant shall file an affidavit of service prior to the next date of listing. List on 12 August 2024.
Oblige.
Oblige, Your Lordship. No. Disposed of. Oh, cross objection?
Cross objection will be taken at the time of.
At the time of final hearing.
Final hearing.
Huh?
Cross objection will be taken at the time of final hearing. Yes, registered.
No, there is no order passed. That's why my court master is pointing out.
Cross
Cross
objection
objection.
is 17/2019.
Heard. Mr. D. Mandal, and I counsel for the applicant. And Mr. S. K. Goswami, then counsel for the opposite party, who is the appellant in the connected appeal. First, this being a cross objection filed in connection with MSC Appeal number 95 of 2017. This cross objection shall be taken up along at the time of hearing at the time of hearing of the corrected appeal.
May I pray, Lordship? It will be better, Lordship, if he also takes steps. Both steps will come, Lordship.
No, Your Lordship.
No. In cross objection, that will cancel.
Your Lordship, in the order it is written applicant, it will be cross objectors.
Oh, sir.
Cross objector.
In cross objection, it will be cross objector. Okay, right, you are right.
Oblige.
For other matters, I am drained out. I won't be able to take up any other matters. Like all hearing, but then all are hearing matters. I won't be able to take up.